Okay.
Which is kind of the objective of this for debate, right? I know, I say that all the time.
For 3 days, I'm telling you what we want.
Yeah, yeah. Because they will learn something.
Oh, yeah, no, that
Right.
yeah, that's not the most important issue.
Yes.
Have you?
Well, every once in a while I go to your webpage.
Yeah.
I don't know if you knew,
I saw that in, I saw that in the bio.
for about 8 years.
Okay.
And, that's how I got into special education
Okay.
stuff. And then when I got hired on public education, I thought, good, I can do special ed anyway. And I mean,
Mistaken.
a lot of years, I mean,
Yeah.
I've just been like a parent.
I am the other one. I'm
I'm Brandy. Still, always have my hands in I guess. Must be me, all right.
Okay. Okay.
I'm her proxy.
Yeah, I did not realize that.
Yes, I'm Hannah Carlock. Yes. Trying to fill her fabulous shoes.
Hi, Angie, how are you doing?
We have, the last couple years we've specialized.
That's mine. Thank you. Sorry. I was taking up your space. How are you doing, Lisa?
So we did, I knew Dave, we used to go to unique times for education case. About 4 years ago, we actually, went to teams. So we have a
For
staff.
the attorney to
So the attorneys only, well, attorneys and advocates, and so we have one attorney who oversees the education. So that's all he does is education. And we have, he's the one, justice one, and Plymouth one for Hope Rehab.
Yeah, it's not intentional.
Do ya? Well, when I was hired in,
Like, dang, I need to get my name together.
we now have, you already have 4 staff.
Yes, I get already printed it out.
Yeah, I got it.
Okay, it is the 1 o'clock hour, and I believe in being respectful of everybody's time, and so therefore, we said we were gonna start at 1, so guess what? We're gonna start at 1. How's that? So how about a roll call, please?
Dr. Balsley?
Here.
Mr. Boehner?
Here.
Mr. Krishan?
Here.
Ms. Carla?
Here.
Dr. Ernest?
Here.
Ms. Long?
Here.
Mr. Mapes?
Here.
Ms. Tanzil?
Here.
Dr. Taylor?
Okay, thank you. And if we could start with the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, first item is approval of the agenda. Could I have a motion to approve the agenda?
So moved.
Second.
Okay, it's been properly moved and seconded. All in favor, say aye. Aye. All opposed? Okay, we are good to go there. Just next item on here, we don't have minutes, so clearly we won't be doing that at this meeting. We'll look at those at the next. Statement of the chair, I really don't have anything other than to say welcome and to say thank you for being a part of this journey that we're gonna be on, together for what I continue to say. We had accountability meeting this morning. We have this now, but in both cases, the objective is to do what's right for our students, right? And so I think as we work through that, that's our objective. But I say thank you for taking this on and being a part of this. So thank you very, very much. Do any of you have any comments that you'd like to make at this time as we get started? Or I would do, we have bios and things, and I'm gonna work off of what Pat did this morning, and maybe we could just quickly have you all just do a quick introduction and what lens I like looking at that, right? What lens are you looking at this through? Because we all have those, right? Even though we're all wanting what's best for students, we all have a different lens that we look through. So if we could start down here, Joel, if you could start. You do not need to push your button or anything, just, yeah.
Thanks for orienting me, Dr. Ernest. My name is Joel Boehner. I'm the Executive Director of the Indiana Resource Center for Families with Special Needs. InSource has existed since 1975. We are Indiana's Parent Training and Information Center. We're one of the first 5 in the country. I have 2 children with IEPs. And that's a big part of my lens. InSource helps thousands of Hoosier families with IEPs every year. So that's part of my lens as well, sir, to be succinct. So.
There you go. Yeah, thank you.
Good afternoon. I'm Angie Balsley. I'm the Executive Director of Earlywood Educational Services. It's an interlocal special education cooperative located in Johnson County, serving 6 school districts. I'm also President-elect of ICASE, the Indiana Council for Administrators of Special Education. We represent over 90% of the public schools in Indiana. Also, my dissertation was on the dispute resolution process and the perspective of the special education director. So I've done thorough lit reviews and spent a couple of years studying this topic. I look forward to being a part of this work. My grandparents were founders of ARC of Indiana back in the time when they said they should take their son with Down syndrome and not have him be part of the public society. So I also represent a family perspective as well.
Okay. You're pretty embedded in this, aren't you?
I was raised in it.
There you
go.
Thank
Absolutely.
So I am not Kim Dotson. I'm here as her proxy for the first meeting. I'm Hannah Carlock, the Director of Public Policy for the ARC of Indiana, and we represent Hoosiers living with disabilities. And so we're there as a resource, just like InSource, not on that level, but we're there for a variety of education, Medicaid, an array of different resources that we offer.
Okay. And I am Byron Ernest. And as I've said before, I taught 26 years, so have that perspective of working with lots of students and every one of them, the thousands different, right? And so that's where some of this passion comes from. And then having been a school leader as well in a turnaround academy, principalship, and those kinds of things, and now working with school leaders, passionate about how do we get the right things for every single student and have those. And I as well, you can't keep your kids out of these things. So my son also has an IEP, orthographic memory deficiency, which is something a lot of people don't know about. Northwestern University has done a great job of teaching us. He graduated this year, but my passion for this comes from how do we make sure that every student is put in a position to learn in the best way that they can, because I think, I firmly believe all students can learn. They learn differently, and we need to make sure that every one of them's in a position to be able to do that. So I am passionate about this work.
I'm Pat Mapes. I'm the superintendent of Perry Township Schools, about 10 minutes south of here. I'm on the committee as I'm the Senate State Board of Education appointee. We serve a little over 2,600 students with special needs in Perry Township Schools. So this process and how to make it best to make certain we get the right services for our students is very important to me. And I've been in education, this is starting my 33rd year.
Lisa Tansel with the Indiana School Boards Association. I'm an attorney by background. I've been with the association for 29 years, but my first job was with the Division of Special Education in the Department of Education. So I'm passionate about public education and what all it can do for the students of our state. But on behalf of school boards who govern the affairs of public school corporations, I'm here to represent their interests.
I'm Dana Long. My first job after college, I guess, was as a school teacher. I taught middle school and, well, at that time it was junior high and high school math. Before going to law school, my first job out of law school was as the magistrate at the Brown Circuit Court. But then I worked for 8 years for Indiana Protection and Advocacy Services, which is now referred to as Indiana Disability Rights, before coming to the Department of Education. So that was my first involvement with representing individuals with disabilities. At the Department of Education, from 95 until about 2013, I suppose, I was in the Office of Legal Affairs, and about 2013 or 14 moved into the Office of Special Education. I have probably been kind of on most sides of disputes, although I haven't represented public schools. I've represented parents, I've represented the department, I advised the Board of Special Education Appeals at the time that we had that board, and now I oversee our dispute resolution process and our complaint investigators.
My name is Tom Krishnan. I'm the managing attorney for Indiana Disability Rights, which is formerly Indiana Protection and Advocacy Services. We are a statewide agency that chiefly promotes the rights of people with disabilities and provides advocacy on behalf of their needs. And we cover all disability rights aspects, but one of our teams is special education, so we have an attorney that is exclusively in this area every single day, representing families and kids with disabilities. So my lens here is ensuring the rights of kids with disabilities to receive a free public education.
Go ahead now with the parent? Okay. My name is Patrick Rhodes. I'm a parent of 4 kids, 2 step-kids. One of them has an IEP. I'm also a complaint investigator with the Indiana Department of Education. I'm also the school-based administrative Medicaid specialist. Prior to that, I was a staff attorney with the Department of Child Services for 4 years, prior U.S. Army as well. But my main focus for purposes of this group is coming from the parent perspective of having children with on IEPs, and then also my perspective as a complaint investigator.
My name is Brady Weatherald, and I am the parent of 3 children, 2 typical children who are now adults, and then my youngest is 17, and he does have a disability and is in the public school system. I received my education in social work, and I work for a local nonprofit as a paralegal. My lens that I'm coming, I have went through my youngest child's whole educational career so far, advocating on his behalf. I am in my 3rd school system since and I've been there for about 4 years now. And I've went all the way through dispute resolution process. I've went through the due process hearing. And so I'm coming from that lens and sharing that information. And I've spoke with hundreds of parents across the state as far as problems that they have within the school system and getting their children the appropriate services.
Thank you. All right, great. Thank you for those comments and your lenses. Do we have any public comments? Okay, we'll always have that on the agenda, and the way we'll do that to be efficient is 3 minutes per person, and then we'll do up to 30 minutes, and then if we have more than that, they can submit those in writing to us. But that way we're always able to be efficient with our meeting with that. And now next thing on the agenda, we do have parent candidates who we've heard from here, and so I would entertain motions to entertain motion on our parent candidates.
Mr. Chair, the ARC of Indiana would like to nominate Brandy Weatherald as a member of this working group.
Okay? Do I have It's been properly moved and seconded that we add Brandy to our group as a parent member. Is there any discussion about that? Okay, we'll take a roll call, please.
Dr. Balsley?
Present.
Mr. Boehner?
Sorry, are we voting on this?
Voting on
motion?
the parent member.
You said roll call, but yes, still the same.
So is that the affirmative?
Affirmative. Thank you.
Affirmative.
Mr. Presson?
Affirmative.
Ms. Carlock?
Affirmative.
Dr. Ernest?
Yes.
Ms. Long?
Yes.
Mr. Mapes?
Yes.
Ms. Tanzo?
Yes.
Okay. Welcome aboard.
Thank you.
And let the record show that she's in attendance. Now, we won't do a roll call again on that. Okay. Do I have any other motions?
Department of Education would nominate Patrick Rhodes.
All right.
Second.
Okay, it's been properly moved and seconded. Do we have any discussion? Okay, let's do a roll call vote. Sorry, I wasn't being specific, was I?
Dr. Balsley?
Yes.
Mr. Boehner?
Yes.
Mr. Presson?
Yes.
Ms. Carlock?
Aye.
Dr. Ernest?
Yes.
Ms. Long?
Yes.
Mr. Mapes?
Yes.
Ms. Tanzo?
Yes.
Motion passes.
Okay, thank you. Welcome aboard. Let the record show that
Present.
our parent members are in place here and present today. Thank you. So next thing on the agenda is just we sent out some norms for you to have. I'm a believer in having some explicit norms that you use for meetings. And I sent out just 8 that are ideas. We can either accept those, add to, make edits, whatever you would like. Those 8 are, and you have them and have had them, assume positive intentions, take an inquiry stance, ground statements in evidence, timely responsiveness, communicate, allow for give and take, address issues, not personalities, and respect the mountain. I always say when we take these things on, they are mountains, and we need to respect and embrace that, right? And so I would just like, if you want to have, if anybody's looked at these, want to add something, take something off, make any edit, we can do that. Anybody have anything that you'd like to add?
Respect the mountain is not a phrase I'm familiar with, and you captured it a little bit there. Could you expound as to what that means, Dr. Ernest? Respect the mountain.
Well, I think we have a large task here, right, to get this right. And so for me, the respect the mountain is just to respect that and to embrace that this will be, this is not going to be easy work probably, but that we're doing it for the right reasons. Is
Thank you.
that good? Okay. Anybody, anything else? Would I have a motion to accept these as our norm?
So moved.
Second.
Okay, it's been properly moved and seconded to accept these as our norms. Can I just do a voice vote on this? Okay, all those in favor?
Aye.
All those opposed? Okay. And with that, I'm just going to back up just out of my immense respect for this individual. Dr. Taylor, earlier, we just went through and gave, who we are. We have the bios, but just a quick who we are and what lens you look at this issue that we're dealing with through.
Well, thank you. First, my apologies for being late. My name is Robert Taylor. Up until 3 weeks ago, I was superintendent of schools at Lebanon Community School Corporation. I had been there for 24 years. Currently, in 3 days, I will be the Associate Director of the Indiana State Public Superintendents Association. So I am here in that capacity. I'm honored to be here working with this group. The lens that I look through almost everything is the lens of how do we improve and how do we make equity and efficiency in what we do to improve cornerstones of decision-making, of end result, and of moving forward. So it's a broad lens, but when you've been in education 42 years, it's good to have a broad lens. because there's so many influences that we have and so many things that come towards us. So again, it's my privilege to be here, and I look forward to being just a small part of this very, very important committee, and looking at forward of learning as well as contributing. So thank you.
Thank you. Thank you. And then next on the agenda is to look at our working group goals discussion, our 1629 language. Tim, were you going to give us an overview on this, right? And you've all had this, and maybe if there's questions or that kind of thing, we'll be efficient with this.
Good afternoon. As Dr. Byron has already described, the legislature in the most recent session established the Education Dispute Resolution Working Group to essentially review the dispute resolution process and identify potential efficiencies in the system or other areas for improvement. So after, as this group is probably aware, that will take place over the next couple of months, after which recommendations will eventually be developed that will be submitted to the Department of Education, the board, as well as the legislature, or the Board of Education, I'm sorry. In addition to that, the legislation requires that the department create a report, which more or less summarizes, and I'll let Dana go into detail on this, but more or less summarizes some of the metrics about how that system works now, and that's obviously going to be later in this meeting.
Okay, thank you very, very much. I appreciate that. Any questions that you all would have about that? I mean, those are our goals: potential efficiencies, room for improvement, make the system work. Anybody? Okay. And I think, again, we have really a pretty wide set of guardrails to work under in that. Whatever is best is what we're able to, whatever was what we're able to make go with that. Does anyone have, and we wrote this on here, are there any additional issues not specifically addressed with 1629 as you've looked at that we need to look at? Anybody?
I don't have any additional. I do have a question on the requirements set forth, just from a logistical, organizational standpoint. I mean, there's 9 itemized things here. Are we going to tick them off and go one by one with discussions, or what's the plan for the coming months? Do we have that set forth yet?
I think that, go ahead, Tim. We have discussed that, but yes, we will work through that as we go with that, by that, down the line. Yep.
Thank you.
Can I make a comment?
Absolutely.
When you talk about the wide guardrails, in 1629, it does also talk about what some of those parameters are. I think it might be helpful to identify that at the outset, such as federal special education law, and then also consideration of any opinions rendered by the U.S. Department of Education as being defining what those guardrails are.
Right.
I think that's important given the pretext for the working group here to identify that as being a cornerstone or a something other kind of analogy to help anchor maybe what we're doing here.
Okay, perfect, thank you. Yeah, we will want to continue to be reminded of that as we go through, right? And as we said today is a lot about the report, digging in on that and some of the history pieces. So yeah, 2 really good points. Thank you very, very much. Anybody else, anything related to that? Okay. Next item, we sent this out ahead of time, and Dana, glad that you're here to walk us through this report. As was stated, this was required within this law to have this report and go through. Lots and lots of information there. Dana, I'd like to turn it over to you to walk us through.
You want me to talk from here or at the podium?
However's best for you. Do you have anything other than you don't have any other visual aids, right? Just the document?
You've got the documents, other
Okay.
I was just.
Anybody
gonna
object to
kind
her
of
just being
summarize
right
that.
there? Because that's probably a more comfortable place and better sound-wise anyway. Everybody good? Dana, stay right there.
Thank you. I appreciate that. For those of you who don't know, I just, not too long, a couple of weeks ago, had surgery, so I'm much more comfortable sitting down rather than standing right now. So the department was required to provide a report to this group at its first meeting. The requirement being that the department shall prepare an initial report for the EDR working group's consideration at its first meeting of readily obtainable information related to the cost of educational disputes, including but not limited to the cost of hearing officers serving in the capacity of hearing officers or mediators pursuant to the requirements of Article 7. Those two things, the cost of hearing officers and mediators, are the only things that are really readily obtainable. We have that information because through our electronic filing system, which we refer to as iChamp, for those, I may be saying things that a lot of you already know, or maybe depending on your level of involvement in dispute resolution, you might not know, but we started a process about 4 or 5 years ago of developing an electronic filing system that now allows us to pull out more data and information than we ever could before. It's still evolving, and not all the information that we would always like is readily obtainable. But we do ask that our hearing officers submit their invoices. They're supposed to develop them through iChamp, and therefore we would have access to that. Schools are responsible to pay hearing officers, and in the report you see that I've given you a summary of what the average cost for the past 3 fiscal years has been for hearings that were resolved short of actually going to hearing requests, and those that actually went to hearing. Now, I will tell you the data for 2019, fiscal year 2019, obviously is incomplete, as fiscal year 2019 went up until June 30th of 2019, and there are a lot of hearings that were filed during that year that are still pending, so we certainly don't have that data. Indiana has a hearing officer fee of $90 an hour for their professional service time, $50 an hour for time that they are in travel status, and then also reimbursement for cost of mileage or hotel or per diem at the state rates, which actually probably saves schools a little bit money because that's typically significantly less than what schools pay their own employees. Cost of mediators. Mediation is a process where the cost of the mediators is paid for by the Indiana Department of Education. Our mediators are paid $500 for mediation sessions that are actually held, $250 if the mediation is canceled, and then mediators are also reimbursed for their travel and costs. In preparation for this, the Indiana Department of Education attempted to conduct a survey of schools for each of the past 3 fiscal years as far as their costs associated with complaints, hearings, and mediations. We sent the survey out. Unfortunately, it was just in the last 2 weeks of school. We only, because we didn't know at the time we were doing this exactly when this first meeting was going to be held, and it was initially looking like it was going to be mid-June. So schools were given a very short time to respond, and some schools were confused as to which, we only sent the surveys to those schools that actually were involved in one of these processes in each of the fiscal years. And some schools lumped them all together over all 3 years, or they lumped their processes together. So I can't give you good statistics, other than I would say just kind of a general information. It does appear that schools pay their own school attorneys significantly more than what the hearing officer fees are. If schools and parents are involved in a due process hearing and they reach a resolution, typically the schools are also paying parent attorneys' fees, and those fees tend to be as much or more than the fees that schools are paying their own attorneys' fees. So that's just general. If you want, during the course of the study, more information on the cost to schools, I would suggest we try some other approach, and maybe Angie can help us work with that on, as far as getting more accurate data. Certainly schools have additional costs, and so do parents, as far as if they're involved in hearings, expert witnesses, the cost of subs to cover classrooms during that, so there's a lot of information that is not readily obtainable by the Department of Education. But schools are almost always involved, represented by attorneys in hearings. They are sometimes also represented in complaints or mediations, although there's not a requirement for that. We've seen examples in a couple of instances where it appears that maybe a public school also reimbursed a parent attorney fee in a mediation or a complaint where there's no legal requirement to do so, but the school chose to do so. In this report, we also thought it would be advantageous to share information with you as far as just some general background information on the 9 areas of study that this committee is charged with looking at. Because part of that is you don't need to reinvent the wheel for those things that are already done, or maybe you need to know where we are to know where you want to go, to kind of go with that. So the first issue was the complaint and investigation requirements that are set forth at 511 IC 7-45-1 that could reduce costs to school corporations and parents of students with disabilities. I would point out there are 2 things about Indiana's regulations concerning complaints that are not required in the federal regulations, and that are probably Indiana does a little bit differently than most other states. And the first of these is that in Indiana, we allow the first 10 days as kind of a dispute resolution process time. That we, before we start really the formal complaint, before we require the school to provide any documentation to us, we encourage the parent and the school, or the complainant, because the complainant does not have to be the parent. We encourage the parties to try and settle, or at least we make sure that they are aware of settlement opportunities before we actually try to resolve that. Indiana also has a reconsideration process where after the complaint report is issued, either the complainant or the school can ask for reconsideration, and the request for reconsideration would then go to the Director of Special Education. All of this has to be done in an outside time period of 60 calendar days with no extensions of time from when we receive the complaint to when the final reconsideration can be completed. So everything has to be kind of move along at clockwork. There's no requirement that a party be represented in a complaint. Either party can choose to do so. There are no fees to file, so there don't have to be any cost associated. Now, that doesn't mean a school doesn't incur cost in their time and effort and whatever in responding to complaints. And certainly, should a school be found in violation, there might be costs involved in any corrective action that is ordered. Okay, recruitment, training, and payment of administrative law.
Can we,
yes.
sorry to interrupt
Yes.
you. Could we take a second after each one of the, and I
Sure,
appreciate
sure.
the way, I really appreciate the way you're doing this. Could we take a minute after each one
area
of
to see if
these
there
and
are
see if
questions?
anybody has things they want to question, discuss about this as we go through from what they saw?
Certainly.
I would just add to thank you for your clarity on the short timeline for schools to respond and the time of year, and maybe the structure of the survey as well didn't give us the data that we'd hoped to have clarity on. So I appreciate you sharing that.
It was a short time, we threw it together. It might have been better had we sent it to ICASE and asked them to send it out first rather than we were sending it to the superintendents because we were trying to get separate individual school data. And, one of the things that we didn't really realize, a lot of the superintendents then send it on to their directors. So for example, you work with 6 school corporations, so it's like we weren't sending it to you because we didn't want you to lump your 6 together. We wanted each one separately. But we also found out, for example, that, I'd get a director saying, well, my school isn't on the drop-down list. Okay, well, probably because you're looking at the survey for the wrong year because, you know. So at any rate, there were a lot of problems with trying to do it in such a short time period. So we could have done a better job, could have explained it better or whatever in the end of the school year in the short time frame. I don't want to fault anybody for that. We were trying to put together something here that could help this group.
And you are correct, it's very hard to quantify that data. I've searched for it nationally, and it's difficult to find.
Yep.
I have a follow-up question as well. You mentioned the first 10 days after the complaint's filed, kind of an informal due process or mediation resolution area. Do you track how many resolved in that 10? Does DOE track that?
I don't think we track how many are resolved within that 10 days. I mean, if you look at the data overall, especially if you look at the cadre compilation of the data, that was one of the documents that was provided, you can see, like, for the written state complaints, that's what we're talking about, the number of complaints that were filed in any particular year versus how many actually went to, all the way to report.
Okay, so is it?
So I can't tell you whether it was resolved within the first 10 days,
Or just
other than it
resolved
was
before the
resolved
report?
before we got to day 40, which is when our report would have to go out.
Okay. That's helpful, thank you.
I have another follow-up question. I know you said that there's, substitute teachers paying for and all of those fees that you really don't have that data on. But do we know, and thank you for the data of like how much the due process is costing our state, but do we know how many of these like aren't really costing? Like how many cases go through without costing us much money since there's no filing complaint charge or anything like that?
Well, a few of the schools did respond on surveys, like on a complaint, okay, that they might have just said administrative costs without designating that, because I'm going to pick on Angie here because she's the director and because she's here. Certainly if I get a complaint filed against one of Burleywood's schools, Angie's probably going to be the one responding to that. It's going to take her time, but Angie, I'm assuming, is paid a salary and not paid hourly and doesn't get paid overtime if she works more than 40 hours in that week. She may work 60 or 80 hours that week.
I usually do.
For the record.
So, that's probably not really a quantifiable cost to say, oh, it cost Burleywood an extra so much money to respond to this complaint. And a lot of things aren't going to be really quantifiable unless there's something like, maybe if they did something really egregious as far as not providing services for a year to a particular kid, we might order compensatory services to be provided, in which case you may be able to sit there and say, hey, yeah, that cost us $100 a week for, 36 weeks, and I can tell you how much that cost. But other than that, it's very rare that probably in a complaint that you can really hang a dollar figure on those costs. Now, when you're talking about attorney's fees, most of those are coming out of hearings, and whether the case goes to hearing or not, when a school gets a request for a hearing, typically they are doing two things. They are notifying their attorney and they're notifying their insurance provider. And those things cost them money right off the top.
I would just add on to that a little bit, Dana, that generally the complaints and then mediations, which we haven't talked about yet, are very low cost to the state, to schools. You're right, the dollars, when we look at a large sum, comes more with due process hearing requests and hearings, both of those. And I also love the questions that you guys are asking, because if we were wanting to collect some data, this is maybe giving us some questions that we would want to put together and collect data moving forward to track. So I think these are really great questions.
To second off of that, could we get a copy of the survey that went out, like a blank one, just to see what was asked?
Yeah.
Just to see what was requested data-wise? That'd be helpful, thank you.
Kim, did you hear that?
Thank you, Kim.
The rest of my staff is sitting back there, so, and Kim is the one that keeps us all in line and takes care of all of that.
I have something to add onto that when talking about cost. I know a lot of times, obviously, we're focusing on the cost to the schools. And one of the things that doesn't often get talked about is the cost to the parents. I can tell you a few years ago, every month I was pulled into an IEP conference because there were some problems going on within the school system. So once a month between September and February that year, I had an IEP conference. And that was a minimum of 2 hours. I am a single mother. I work full-time. Because of other services that were not being provided in the school, I also had to take off of work in order to go take him to those other services because I wasn't able to access those within the school system. And we don't have, parents don't have insurance that covers our attorney fees. We have to pay that cost. I depleted my savings account to pay for an attorney. I had no other option. I sold antiques to pay for an attorney. Parents, we do things that we have to do in order to access those services. The time that we spend away from our jobs can also cost us our jobs. And so when we talk about it, I just want to make sure that that's something that's also being taken into consideration, because I don't know of any parents that do it to be frivolous. It's because our children are not receiving the services, and we're advocating and doing what we need to do.
I do have another question for you, Dana. So you said that, let's just say, like, the child wasn't receiving services for like a year, and we have to like backtrack and make sure that they get those services. Do we have like the average, like any data on what schools pay for students to receive these services? Like how much it usually costs schools to provide?
That come out of complaints, the corrective action?
No, just to provide special education services. Do we have data on that?
Like compensatory services?
Yes.
Yeah, I can't answer that for compensatory services. You know, I mean, there are two different things. I mean, one thing that comes out of hearings, and something a hearing officer orders is usually much more extensive than what the department orders. And part of that is a difference of what we're looking at. While in a complaint, we can look at any potential violation of the IDEA regulations or Article 7. For the most part, we are looking at procedural compliance. And most of our corrective action ends up not being so much child-specific as far as providing additional services to an individual student. It's more like we did this complaint and we found out, yeah, school, you didn't give the parent prior written notice of the proposed placement, or you didn't do this. Our corrective action tends oftentimes to be ordering the school to do in-service training, to train its staff, to do certain things. It happens, you know, sometimes if we find that, hey, you didn't provide speech-language therapy that was as identified in the student's IEP. Typically when that happens, it's because there's a real shortage of speech-language pathologists, and the school was they had someone quit and they were unable to hire someone. So we will tend to say, okay, show us that you're advertising, show us that you're trying to fill the position, whatever, but then we will make you at some point, hire somebody outside, do it from the medical model, do it whatever. That type of service, tends to be a compensatory service that we might order. But most of our corrective action and complaints tends to be more on the procedural compliance and making sure that your staff understands the requirements of Article 7 and that they're appropriately trained to do that.
Thank you.
In putting on my investigator hat, usually we're going to, in an investigation like that, if it's involving compensatory services, it's something where the IEP wasn't implemented as written. IEPs usually measure services by hours, so as corrective action, we're going to measure it by hours. You didn't do 40 hours, do 40 hours by a certain date or whatever.
Okay.
Yeah.
Thank you.
It's also extraordinarily difficult to usually make up all those compensatory hours as well. It's just impossible time-wise. So if they missed 40 hours, they might not receive all those compensatory as well. So I think it'd be interesting, but I think it'd be extraordinarily difficult to track and try to track down those in all instances.
Okay.
I wonder, for any final report, do you feel like it's relevant to distinguish between the complaint investigation process and the hearing process? You just mentioned that.
Well, this particular question or issue had to do with the complaint and investigation process on number one that we were
Right,
talking about.
but again, I think
Yeah.
that we all around this table know the difference between the complaint investigation versus the hearing process. And so I'm just suggesting for a future report, we might want to make sure the public understands the differences so that they understand the difference in the costs as well.
Right, yeah.
Yeah,
I think that would
I
be
echo
good.
that. I think it's very important to distinguish the three, the mediation, the complaint versus due process, because they're very different strategies.
Anybody else?
Okay, number two, the recruitment, training, and payment of administrative law judges or hearing officers. I provided information that's on pages 4 and 5 of your report that sets forth the qualifications of hearing officers. This is a combination of what's actually set forth in Article 7 as well as our internal policies and procedures. Recruitment of hearing officers, the process we've used most recently is also set forth there, where we've advertised it on our website. We've advertised it to the Indiana State Bar Association since 2014. Since January of 2014, all administrative law judges in Indiana do have to be attorneys. So, you know, we used to have a combination of probably half of our hearing officers were attorneys and half were either university professors or psychologists. We do have a couple still that are not attorneys because they were grandfathered in. Good thing about that is it allowed us to have people who had more knowledge in the area of special education and that background versus just the legal experience. However, the General Assembly has foreclosed that avenue to us. But we are, you know, another part of this particular bill that we are working under also requires that after July 1 of 2019, that any new hearing officers or mediators that are recruited have to be trained to serve both as hearing officers and mediators and agree to serve in that role. We are currently have just started to recruit again for hearing officers and mediators, so now it's a combined process. And that the application processes or application and everything is posted on our webpage, and it has just been advertised in the Indiana State Bar Association's electronic email that is called Addendum. It will be in their next published magazine called Res Gestae, and then again in the next issue of the Addendum to get that information out. So if you know of any qualified mediators, people who have been through the training of mediation and are in the Supreme Court's Registry of Mediators, as well as being licensed attorneys, those would be the first two basic requirements to serve as hearing officers and mediators. So payment of hearing officers, as I indicated earlier, they currently get paid $90 an hour. That has been the same rate for close to 20 years that we've done. That's not increased. We did send out a questionnaire to Cadre that I mentioned. They have 3 listservs for people in my position across the country at different states that for both for mediation, complaints, and hearings. And so I put the question out there as far as what other states pay their hearing officers. And some states do have like an Office of Administrative Law Judges where the hearing officers are state employees. However, some contract with them or do something similar to what we do. The next lowest rate that any other state pays has been $125. So we are well below probably what hearing officers should be paid for what they are doing. So the training that we provide for new hearing officers and mediators, we have followed kind of a similar type of process, is that we have a day that we refer to as new hearing officer training or new mediator training, where we spend the day going over the basic requirements of Article 7 and provide some background information on some of the major Supreme Court cases. We also now, about 4 years ago, we developed a procedures manual that sets forth the basic requirements of AOPA and hearings under Article 7. And so we go through all of that information. We also then require that they participate in our annual 2-day training that we have for hearing officers. And that we also then require that they basically are mentored by an experienced hearing officer and follow the process of a hearing. That has actually been one of the most difficult aspects of our training to get through, because there are so few hearings anymore that actually, hearing requests that actually result in a hearing. So it has become extremely difficult to provide new hearing officers the opportunity to actually observe a hearing. But it has resulted in it taking anywhere from a year to 4 years for a new hearing officer to get on board and for them to feel comfortable in assuming that role. This year, because of the requirement here, we have also offered our current hearing officers and mediators the opportunity to be cross-trained as the other one if they are interested. And we have, I think, 3 of our current hearing officers who have expressed an interest in becoming a mediator, and we'll be going through the mediator training. Mediator training in Indiana, and probably in most states, it's a 40-hour course just to be a mediator, okay?
40?
It's a 40-hour course. ICLEF puts those on, or they're offered, you can find them on their website. When Indiana's special education first started mediation back in the early 90s, before there was a registry in Indiana, the Indiana Department of Education, I say we, even though I wasn't here at that time, did provide the 40-hour training for the first group of mediators to be qualified to serve as mediators. That was through hiring some folks out of Illinois. I can't tell you now who that was. Sally Hamburg, previously at InSource, probably could give you that background information. And for the second round of mediators that were trained, that probably came about in the mid-90s, we had that same group come back to do the mediator training. Around 1996-97 is when requirements for mediation in Indiana became codified generally, and we started the Supreme Court Registry of Mediators. After that time, the Indiana Department of Education no longer offered the 40-hour training for mediators. So what's required now is on the registry, you can either be a civil mediator, which requires the 40-hour training, but you also have to be a licensed attorney and go through that, or domestic relations mediators. Domestic relations mediators are not required to be attorneys. All of our current mediators are attorneys, so they meet that requirement. But going forward, they would all have to still be attorneys anyway, because they would have to be cross-trained both as a hearing officer and a mediator. So with all of those requirements, they'll have to meet both sets of requirements. I'm not sure I understand what the purpose was of that, but we will do the General Assembly's bidding.
Dana, to that point, that requirement only came from our state legislature, correct?
For being cross-trained?
Right.
Yes, yes.
Okay.
That is not a federal requirement at all, and I'm not aware of that being required in any other state. When I put out the questions on the cadre listservs, those that responded were surprised. They'd never heard of such a requirement and thought that they didn't understand the purpose because they required 2 different skill sets and it's not the same thing. But,
Well, I was asking because it had not jumped out on me when I was initially reading and studying this, but then it did when you made the comment of we had people who really knew education, right? And that came into my mind of, is that a barrier, I guess, from my standpoint? I'm thinking, well, gosh, do you get the most knowledgeable people? Yes, they're attorneys, but to me, probably the more important piece is the knowledge, right, of the special education situation.
yes, I would agree.
You would agree with what I'm saying there? Okay.
Yes.
I want to make sure I wasn't missing something in my mind. I appreciate that. Thank you.
I think part of the intent of it too was that so that hearing officers could see the interactive process between families and schools and be more informed of that when they get to the point of just the hearing as well. I think that was a little bit of the intention behind the cross-training.
Okay.
I would imagine though, and correct me if I'm wrong, I guess, if you're the mediator in a mediation, you probably cannot be the hearing officer, correct?
Right,
Okay.
right, you couldn't be involved in the same.
Right, okay.
Both roles. in
So
the
it's just
same
a matter of
place.
kind of seeing the process, but not necessarily that specific process.
Yes.
I do have a question. There was I think, and Hannah would know better than I would, the ALJ law where they pushed ALJs out of the agencies into the one collective. Did that pass?
I do not believe so.
Okay, I thought it did. Okay.
I had a bit of a broader question in where the Education Dispute Resolution Working Group. Are we focused solely on special education, or are we open to all education disputes that come before school corporations with families? I know that a lot of the activity does occur around students with disabilities, but I'm curious about the scope of our work in regards to all disputes in schools.
I'm gonna ask Tim to make sure. I thought it was with disabilities. Am I right there, or do we scope beyond that?
Sorry, can you repeat the question?
Repeat your question so we get this right.
So I was inquiring about the scope of the work of our committee. We're talking, we have a lot of folks around here that understand individuals with disabilities and families in that process. But we are the Education Dispute Resolution Committee, and there are other disputes that come before schools with employees, with families, with other issues. Lisa could probably speak more to that, or our two superintendents here could speak more to that. So I'm wondering what we're speaking of and the precedents we're setting, the processes we're discussing, would that extend to other areas of dispute outside of just special education as well?
So that's an excellent question, and the legislation was not limiting in that way, in that this group could only consider and make recommendations specific to special education. I'll read an excerpt here. On or before November 1, 2019, the EDR working group shall study and make recommendations to the Department, State Board, and the General Assembly regarding the following topics or other state education laws. The following topics are those 9 points that Mr. Boehner referenced earlier. So the other education laws would suggest that if this group were interested in pursuing, making recommendations on other areas of dispute resolution, you may do so.
Part of my, thank you for that, seeking clarity on that is, what is the process outside of special education? I'm very familiar with that part, but the ALJ process and, this is an administrative law. This isn't court, and sometimes when we get into talking about due process hearings, it feels very Perry Mason-like or courtroom-like for families, for schools, for everybody. It becomes more than just we're enacting our administrative laws. And so I'm curious about the similarities and overlaps, or what we could learn from our general just education resolutions and the ALJ process as well.
Angie, I'm not aware that there are any other processes that allow parents of kids without disabilities any similar type of administrative remedies that kids with disabilities are entitled to.
That includes non-disability discipline as well? So if suspension and expulsion is not an appeal process, because I'm ignorant to that side as well.
Suspension and expulsion is handled at the local school level. It's not subject to AOPA, and there is a statutory requirement that talks to, to the discipline. You can have a local expulsion examiner, which is your superintendent or your superintendent's designee. That can be appealed to your school board unless the school board chooses not to hear it, and then it goes to court. There is no administrative law judge that's subject to AOPA.
Tim, did you have a comment related to that?
I did. I did want to note that although the language in the legislation wasn't restrictive, specific to special education, I think it's worth noting that obviously special education is a very unique and time-consuming area for review. And given the time constraints that this committee is subject to, it might be worth considering limiting the review here for the November recommendations to special education dispute resolution.
I would note as well, in addition to his comments, I know the list of 9 is non-exhaustive because it gives us that opening to kind of look at other educational aspects. But 8 of the 9, excuse me, 8 of the 9 are either Article 7 or special education related. So I think the focus is certainly going to be on that. The only one that's not is whether dispute resolution ombudsman within the department can reduce costs, and it doesn't sound like that's going to be in play in the non-disability kind of discipline area. So I think the 9 itemized are probably all intended to focus on disability specifically.
And I agree, and my passion too is around special education. Lisa, I'm sorry, I may have cut you off. I just wonder what we can learn from the other practices and what we might apply to our thinking in this group through that as well.
May I ask some questions about the hearing officer training? Is there any evaluation process for the hearing officers? You've talked about how you recruit and how you train. So is there any kind of evaluation or assessment?
The evaluation of hearing officers has always been a very, very difficult area. A number of years ago, I can't even tell you how long ago, Lisa, and whether you were still at the department or not at the department or whatever, I know that we tried some sort of evaluation, like asking the parties to fill out an evaluation of the hearing officers. And the results always tended to be, hearing officer ruled in my favor, the hearing officer was great. Hearing officer ruled against me, they stunk. You know, I mean, we didn't find it to be extremely helpful. What we tended to use, and when I asked Kevin McDowell, our former general counsel, about evaluation process, what was most helpful was when we had the Board of Special Education Appeals, because here you had an appellate body, if you will, a review process where you have a 3-member independent panel that is going to review the entire decision. This Board of Special Education Appeals reviewed the entire record. They read the transcript, they read all the exhibits, all the pleadings, if you will, and then reviewed the hearing officer's decision. Now, they were not there to substitute their judgment for that of the hearing officer. They were only supposed to, reverse or change anything if they found that the hearing officer's decision was not supported by substantial evidence or was contrary to law, or there were certain, parameters there. But there were a few instances where they found that the hearing officer really missed the mark, either on law or procedure. It was a great way to then get the information back to that hearing officer to say, hey, look at this, you need to do some things here. Or it led the Department of Education to sit there and say, okay, here are some other issues we really need to look at training. One of the things that is most difficult for us, I think, at the department is they are independent hearing officers. They should not be looking over their shoulder to say, oh, well, if Dr. Holzapfel or Dana Long don't like my decision, I'm going to be removed. Then that means they're not independent hearing officers if they're subject to my review, So it's been difficult. We do try and pay attention to things if we hear from parent attorneys or school attorneys of particular issues and make sure we address that. But other than that, unless a hearing officer has just, we have a hearing officer who consistently doesn't meet timelines, if we meet with them and talk to them, but, that's kind of, a party will say that's kind of a minor procedural thing. It's a big procedural thing for us when we have to report to the feds whether or not we met timelines. But in the grand scheme of things, you probably as a party don't mind that the decision was 30 days late if it was correct,
Or favorable.
Or favorable. Those terms might be interchangeable depending on where you are with it. So it's been very difficult to come up with a good means of review, and very few cases anymore actually go all the way to hearing, and of those that do, not many get appealed onto court. And even when they do, we don't have a good mechanism of tracking all that, because the parties would have to tell us it was appealed and here's the cause number, give us a copy of the decision. And the federal court probably doesn't necessarily go through it as minutely, probably as what the Board of Special Education Appeals did. So we are certainly open to suggestions on methods to evaluate hearing officers without overstepping that line of them being independent hearing officers.
Did you have a follow-up?
I
to that,
do,
Liz?
thank you.
Please.
What kind of assistance would be available to a hearing officer from the Department of Education, outside of this very formal training? So for instance, does the independent hearing officer ever have the opportunity to contact the Department of Education with a very specific question about an issue that is currently before them?
Yeah, that's a very difficult thing because I don't want you to contact me about a specific question before you right now because I don't want to make that decision for you. You're an independent hearing officer. So that's not to say that hearing officers haven't contacted us. And I will say, I can't answer specific questions. You can give me a hypothetical. But we would sometimes, too, suggest that, why don't you contact one of the more experienced hearing officers and run it by them, or someone who's an attorney if you're not an attorney, and it's too legal, because these questions shouldn't be Dana's decision. It should be the hearing officer's decision.
I just wondered with the states that maybe have the Office of Administrative Law Judges, whether they're in a position to offer that procedural guidance. And I should have spoken earlier.
Yeah.
I only mean as far as procedural guidance in running the hearing and dealing with motions.
Because, certainly there are some things when I can sit there and say, well, hey, take a look at this section of AOPA, or take a look at this section in Article 7, if it's really kind of a cut and dried procedural type of thing.
I have a suggestion. I know there's so few due process hearings that go through, so it may not be of special value, but I think either Marion County or the state, I think it's Marion County, will survey the bar, the attorneys in Marion County yearly on the judges and kind of their timeliness, their fairness, and et cetera. So that may be of some value to just send surveys out to the attorneys who have been before all the ALJs or the hearing officers that year, instead of maybe the jaded responses you might get immediately after losing the hearing.
I like that,
It
yeah.
might be a little more kind of they've had some time to sleep on it, and they can think back and say, yes, my experiences, they were fair, they were timely, and you may get kind of a more general sense of the true, thoughts on that hearing officer. Again, I don't know or have any recommendations on what the DOE does with that information, since they are independent and need to be independent. But to get a kind of sense of, the individuals who are practicing in front of those hearing officers, that may be a good way to do so. Kind of just a general survey at the end of the year, or every 2 years or whatever.
I like that suggestion. I hadn't thought about it in terms of just doing like an annual survey. What we tried to do was kind of in response to a particular hearing. And I kind of like that. Because we do evaluate, or have, in the past, and we're trying to revise it again for our mediators, send out evaluations, and we've gotten at times good responses and other times not so good, but on an individual basis. But that's a good idea because there is really a rather limited bar that is.
It is, yeah. Very few.
Involved in special education hearings on a regular basis.
Mm-hmm.
Dana, you'd mentioned the BSEA, and I know you've got a point about that later, so I won't ask a lot of detailed questions now. But while we're thinking of the theme of oversight, I'm curious, did the BSEA review all cases or just ones that were appealed to them?
Just those that were appealed.
Okay. I believe an opportunity for us to consider here is cases that are settled. When we look at about 100 requests in Indiana per year and 95 are getting settled, Like, what goes into that process and why can't it be settled beforehand? And then who's reviewing it? Where's the oversight to make sure that the process was good for families and schools, that the outcomes were in the best interest of kids? I just think there's an opportunity. There's a lot of action that happens around the cases, the requests that are settled, yet I don't know that we have much of an oversight into that.
Yeah, I don't think there's any oversight that I'm aware of. Largely also, and we'll get to this point as well, but most of the schools require confidentiality clauses in those agreements. So it's hard to glean feelings or thoughts or even outcomes of those settlements when both parties are prohibited from talking about it as well.
I'd like to add something. I feel that before a parent files a complaint, I mean, I'm sure that there are some cases where parents file complaints early, but I feel that by the time a parent files a complaint or files for due process, they have tried to resolve the issues that they're having with the school. I mean, it took me probably 6 years to even get my child an IEP. And I would be interested to find out, like, who is a school accountable to when there is a complaint filed and then there is a settlement or a due process filed and there's a settlement agreement and we have the non-disclosure, so we can't talk about it. Who is going back to the school and saying, okay, well, why wasn't this resolved before now? Why did it have to get to this point before there's a settlement? I hope I worded that correct.
I think I hear you saying opportunities for learning and how we could be proactive in those situations in the future based on outcomes of those. Is that kind of what you're getting at?
Well, I can kind of, because it shouldn't take having to file a complaint or a due process to get what you've been trying to get. Because sometimes the moment you file a due process, then the school wants to settle, but you can be in meeting after meeting after meeting, and what you're asking for is not an option until you file for that due process. And that's not unique. I mean, that happens to parents quite often. And so why are the situations not getting resolved before it gets to that point? Parents use InSource. We have advocates that go InSource. They're neutral parties. And so there's a lot of steps that parents take before they get to the point of filing a complaint most of the time, or even filing for due process. I'm not saying there's never any due processes or complaints filed that maybe shouldn't be, or maybe that's the first step that somebody took, because I'm sure that happens. But for the most part, I don't feel that that's what parents are doing. They're trying to work with the schools.
I want to thank Brandy for pointing that out. And say that I think that's an accurate characterization of how parents interact with this. The parents that I've heard from talk about feeling like they have to walk on eggshells when they get into dispute resolution. They realize there's relational costs involved, and you do not take it lightly, and you do not particularly enjoy it. And I also want to thank Brandy for sharing about her personal experience. And someone in this room just said depleted their savings account, and I think that's something we need to think about as well. So I resonate with your question. I too wonder what's the magic about this step that these other steps where bringing an in-source program specialist to the meeting doesn't get you there. Maybe a facilitated IEP doesn't get you there. Maybe this mediation doesn't get you there. What about this? Okay, I'll press this button now, and that changes the game. And that's the button that costs money, and that's when we start to roll through those more those less efficient options. I wonder that as well. I've been thinking, what is it about that? Because I again, back to Brandy's characterization, parents don't love jumping into it. And there may be exceptions, but parents don't love jumping into it, and yeah. So, sorry, I wish I had a better conclusion for my stream of thoughts there.
Okay, number 3, a system of access to low-cost legal advocacy regarding educational disputes that encourages the efficient resolution of disputes and does not incentivize protraction. I would point out that both federal and state law require that schools advise parents, provide information to parents, at least if a parent has requested a due process hearing, of the availability of low-cost or no-cost legal representation. That's a very, very difficult thing to do. The information that we have provided in our sample of notice of procedural safeguards that the Department of Education posts on its webpage that a lot of schools kind of use wholesale, provides information about special kids, Indiana disability rights, disability legal services of Indiana, and InSource. And not all of these would represent parents at due process hearings anyway. Additionally, in our publication, Navigating the Course, we've also added the Joseph Maley Institute, and I suppose we could add them to the Notice of Procedural Safeguards as well. It's very difficult to find someone that is going to go out there and represent parents with, at no cost. And even if they do, that doesn't mean that in a hearing that the parents will still be asking to recover attorney's fees for that organization. I don't want to speak for Tom here, but at the time that I was at Indiana Protection and Advocacy Services, I had 1, 2, 3, at least 4 cases that I am representing an individual with a disability in a due process hearing and sometimes subsequently on appeal, that we did recover attorney's fees. The last of those actually being against the Indiana Department of Education.
Do they know that you did that?
Department of Education. Oh, yeah. Yeah, actually, the final check for that came like about a month after I started working at DOE. So yeah, they were certainly very much aware of that. But so to sit there and say, when I was at, we referred to it as P&A at that time. When I was there, we didn't charge parents attorney's fees. However, in those cases that we actually took to hearing, we did, in a few cases, recover attorney's fees. However, we did not include attorney's fees in any settlement agreement if we settled the case short of going to hearing. So that's a difference between what we did there versus what most private practice parent attorneys are going to do now. They're going to still be recovering attorney's fees for their clients, and I can't fault them for doing that as part of their settlement agreement. But to find somebody out there that is going to represent parents at no cost is a very difficult thing for schools to be able to say, hey, you're a parent, here's a list of organizations that can represent you. But if anyone's aware of anyone else that we can put out there and make that information available to schools, we are, I'd be more than happy to hear that.
If I could just update where the P&A is now. We do represent parents and families for no cost. We don't charge them. We have anywhere from 30 to 40 active cases at any given time in just special education. We start at the low level with advocates who attend case conferences and communicate with schools, and then we'll move it from there. We do file due process. We do represent families and parents in due process filings, although it is few, as it's few in Indiana generally. But when we get to that point, we do represent and we do seek fees. We feel that if it's gotten to that point, we've exhausted what we can exhaust. We advocate hard with the schools and attend many case conferences, try to obtain FAPE as we feel is appropriate. We can utilize the complaint procedure, we utilize mediation, and then when necessary, we do utilize due process. So, but yeah, we do recover fees when it comes to that point. But it's certainly not something we jump to either. It is a very calculated decision, and it's not a quick decision in our instance. But we absolutely do. We don't charge parents or families any legal fees for our representation.
I do have a question. So in the conversations with schools and parents, I know, like, starting in a school when my brother, when he had his IEP, like, my parents were handed a lot of information. I know that they did not read every brochure and every paper that was in that packet. So I know a lot of that information, like IDR and InSource, is within there. So are they being told in a meeting that you do have these services, like in person, saying, hey, InSource is a thing, IDR is a thing, or is it just on a piece of paper, they check that off their list? Because I'd rather, job security for you, but I'd rather people, use IDR and the free services with no legal fees, because that would end up saving a whole lot of money, and you do know the process already, where going to a private practicing attorney, this might not be an everyday thing for them, and it is very costly, just because my dad's a private practice attorney.
I largely think, and Angie would know much better than I would, or, especially over our case, I think it's largely on NOP, isn't it? I mean, it's just on the notice of procedures, and it's listed there, and there's no verbal, hey, there's some other people that can help you here. There may be some parent advocates, some other advocates that might help you for free. I think it's in that stack of papers that they receive, but I could be wrong.
It definitely is in that information that we provide. However, given at case conferences, there should be a summary of the case conference and the procedural safeguard rights for the families. I know a lot of directors too will encourage families. Like, we've got great partnerships with InSource and Ask and IDR. We encourage to be able to solve early. So there is that verbal, especially when we see that a parent's got questions and is needing some resources, that we encourage them to invite, and we arrange case conferences around opportunities when other folks can come and participate in the conferences with us. I hear you saying here, Dana, like we've got this and we're putting it out, and so if anybody knows any others, we'll add them to the list, let us know. I do think, again, this is an opportunity for our group to look at practices in other states. And I've listened to some Cadre webinars. I've searched the Cadre website. I think there are some great proactive practices in other states that we could help, just like you said, Hannah, with your parents. Like, is there, beyond the brochures that they receive, opportunities for them to become educated stakeholders as well? Are we training our parents? As a special ed director, our own, are we training our teachers in our schools and our public agency reps and principals that sit at the case conferences in this very, very important topic and in their legal literacy around this? So I do see this area too as another great opportunity for us.
Since InSource is named in this section, I feel like I should say a thing or two. First is we're not lawyers, so we provide training and information about Article 7 and special education process. We are a no-cost service, and we help a lot of families do essentially what happens when Dana was talking about independent hearing officers consulting Article 7. We do that with families. We do that with school personnel. We open the binder with Article 7 around the table and try to solve it there, and then at a much lower cost than private attorneys. So we do a lot of that each year, and I can bring an annual report to a future meeting if that would be helpful. I want to pick up Hannah's point about the information that a parent gets as they interact with special education. Brandy, Patrick, it's a lot, right? I mean, so you get the notice of procedural safeguards. By the time you're through page 2, you're just kind of like, okay. And Angie's mentioning a common practice, though not a formal practice, of indicating what resources are available. And to digest a legal document as a layperson is not entirely impossible, but pretty darn hard. And directors who want parents to know who they can talk to for more information will point that out. Directors aren't at every case conference, and sometimes it just gets missed, and there's other reasons why that might not happen. Sometimes the notice itself is printed on really, really small print. It's hard to even read the fine print. So maybe that's something for the working group to explore here, is consistent with number 3, how does this low-cost legal advocacy get presented to stakeholders in the process? Is it presented uniformly beyond, here's the notice of procedural safeguards? And I'm not asking for any more business because we're pretty darn busy, but I do think it would be helpful for the purpose of the group.
I can say that I have never, and I've probably, I'm not kidding, probably sat in 100 IEP meetings over the years. And I am handed that piece of paper, but I can tell you that not one time have I ever had anyone in 3 school systems explain to me what my options were. Not one time. And most parents don't know that. And in some school systems, maybe they do that. But it is not something, you are handed that package, this is, here you go, but it is not explained what our options are or any low-cost advocacy options are at the meetings.
I know just as an investigator, I mean, when I started this job, it took a while for me just to read this stuff and have it wash over me and get familiar with it. And even being an attorney before DOE and going to these meetings and actually just, learning the ins and outs of an IEP is pretty daunting. So yeah, I second that as well.
Navigating the Course is a great resource for special education law in common language. Can I propose an idea, Dr. Ernest, just to say that maybe some version, Navigating the Course type version of those procedural safeguards might be helpful. Navigating the Course is how I started learning about special education with my kids, and then I transitioned over to the big one, the law itself. But I think that's how a lot of families start to know and understand in terms that are just more accessible for people who aren't lawyers or not special educators. So that might be helpful as well.
One thing I would point out on that, Joel, is probably about 3 or 4 years ago, maybe not quite that long ago, as we periodically review our policies and procedures on things, and I looked at our sample notice of procedural safeguards that we had there, and I started to tell Tracy, one of our complaint investigators, oh, we need to pare this down. It's just way too wordy, and and it's like. And then I looked at, what we had out there. This is a sample for schools to use. And then I realized it came from the feds. This is what they said to do. So I backed off on that because it's like we were taking our marching orders from OSEP.
Yeah, I would say OSEP doesn't say talk to InSource either, so there's the opportunity to not amend, but to perhaps add a summary, because it's too much to understand.
It is. When you get a 25-page document, say, here's your notice of procedural safeguards, and I don't know how many pages it is, but it's somewhere in that neighborhood.
Yeah, on top of the IEP, which you care more about at that moment, so I think there's an opportunity to add understanding without reducing the, you won't hear me endorse reducing the federal requirement. I want to make that clear, but not at all in any way. But I do think there'd be some way to help a parent more concisely understand what they can do, because that document really does lay out their options. It really does. That's where that is laid out.
Perhaps if we could do something that's just a 1 or 2 page bullet point
Yes.
of this, then making reference
Yes.
to the full notice of procedural safeguards.
Yes.
I don't know.
I don't know either.
Something we ought to look into.
Yeah.
Number 4, implications to the receipt of federal funding regarding changes made to Article 7. As you're probably all aware, the Individuals with Disabilities Education Act was enacted pursuant to the spending clause, which means states, if you want the money that comes with this, then you accept the provisions here. And OSEP, the Office of Special Education Programs, monitors us, DOE, who is the state educational agency in Indiana, for compliance, similarly to how we monitor the public schools in Indiana for compliance. So we have to jump through their hoops, just like, Angie, we make you jump through ours. So this is what we have to do. Every November 1st, we have a report that we have to submit to the feds. It covers a lot of areas of special education, not just the due process piece. But we most recently received our findings from last November indicating that we met the requirements, which is the highest of the ratings. If you don't meet the requirements, then OSEP imposes sanctions or corrective action. And if you are too long out of compliance, they can then make you pay back or withhold your continued federal funding. There is a hearing process for that, but hopefully we're not going to go that way since we, right now, have met the requirements. In preparation for this, this meeting, this Education Dispute Resolution Working Group, our team did participate in OSEP's Part B self-assessment. This is a document that Cadre put together, and it's set forth, it's one of the documents that was provided to you along with our report here. It set forth all the requirements under the Part B regulations for dispute resolution, for complaints, for hearings, for mediations, for expedited hearings, resolution meetings, and required us to go through and look at our regulations, our policies and procedures, and our notice of procedural safeguards to make sure that we were covering everything that was required under the federal law. So we did that. We provided, you've got the copy of the written report that we did. We provided that back to OSEP and then had a telephone conference with their staff. So I feel pretty confident that Indiana's requirements pretty much meet the requirements of the federal regulations. And for the most part, our state regulations do mirror the requirements of federal regulations. So, any questions on that one?
Is that self-assessment, was that required? And if so, how often does OSEP require that?
It's not required.
Okay.
It was a voluntary process.
Okay.
Will we be going through that as well as a group, or is this question the opportunity to look at that information as well?
I provided the information to you if you have any questions about it. I mean, it's just really going through and it shows, you know, under Part B, you know, 34 CFR 300.356 or whatever requires this. So, and then we would find out in Indiana, where does our regulation, where is our comparable one?
It's a very nice legal map. It really is.
It's a very
Yeah.
nice legal map, yeah.
And I wonder, you know, Dana, you mentioned us jumping through the state hoops, and, you know, you're right, we have those so that we can be accountable for children, right? When we look at the report here, and it's really good, and we're meeting requirements. But as you know, in Indiana, we've shifted to the results-driven accountability, and we're trying to get beyond just meeting requirements and meeting compliance. We're trying to drive better services for kids and outcomes for kids. So I believe that, too, is another chance for us to look at, great, we meet all the requirements, but what can we do that's even better than that? Where can we come together as leaders on behalf of families and children and become beyond just meeting requirements and improving our services and our efficiencies too? And so I think the legal map that you put out is really helpful in us in thinking about that work.
Can I talk to that, actually? I think results-driven accountability is the way there, Angie. So for those of us not as steeped in special ed, but special education is moving from a compliance-based model to a results-driven model. And I think paying attention to our state's excellent work with RDA is a way forward with that, and seeking further engagement, as I know there are stakeholder meetings that the department holds around results. And as a parent, I would say results are huge, right? That's what you want to see. That's why my kid goes to school. That's why they're learning how to read, write, add, all the stuff they learn at school. And it, kind of see them, the compliance and the results are two pieces of the puzzle. And I would welcome opportunities to think, how could we become better at special education in Indiana? How could we become a place where students with disabilities are more employed, are more successful following their graduation, K-12 education? Let's be the best at that. I thank you for pointing that out, Angie. I'm with you on that one for sure.
Yeah. Absolutely, yes.
Dana, when was this self-assessment done?
In the past few months.
Oh, really? Okay.
Recently. I mean, It was driven in response to this.
Okay.
I mean, because of this group going to be looking at our dispute resolution processes, we thought a good way to start was to, hey, let's do a self-assessment and look at where we are.
Well, I appreciate it. It's a very, like Angie mentioned, it's a very good legal roadmap for, federal and state requirements. It's very helpful.
Okay, number 5, information and communication strategies to parents of students with disabilities and school corporations for resolving disputes concerning special education issues. Again, I just want to reiterate that what I'm putting forth here is just kind of telling you where we are at, not saying, oh, it's done. We're certainly open to additional suggestions. So, as Joel has mentioned, navigating the course is a document that the Department of Education, Office of Special Education has had for a number of years. Before that, we had a document called Live, Learn, Work, and Play. So you can kind of forget that unless you've been around here a long time and you remember that to say navigating the course took its place. So on our website, we do provide links to Article 7, to navigating the course, to notice the procedural safeguards, and we have some other links. The Indiana Department of Education's, our dispute resolution team, previously referred to as the due process team, we are trying to focus more on other avenues of dispute resolution. This was actually kind of suggested to us by the Northwest Roundtable last year when I was doing a presentation there. As they pointed out to you, go to the Office of Special Education's webpage, and the first thing you see is dispute resolution. And you go, and it takes you to a link to iChamp and file a complaint and do this, and it's like...
It was due process. The first thing you saw was due process.
First thing you saw was due process. Right. And it's like, well, but, if you call us and talk to us, we don't say that. We say, have you talked to your teacher? Have you talked to the teacher of record? Have you talked to your director? Have you, done all these things? Have you asked to reconvene the case conference? As we communicate with parents, we encourage other methods of trying to resolve things short of using one of these formal processes. So we did put out a real concerted effort last summer when we had a summer intern work with us to come up with a redesign on our webpage to talk about dispute resolution as opposed to due process, to put informal dispute resolution options first before you got down to looking at the more formal processes. However, summer intern goes back to school and we're still all overwhelmed. So it hasn't happened. We have another summer intern now who's helping us to finish the process and the project, and my whole team has as one of our goals this year to get that done, to change the webpage so that it more accurately reflects informal dispute resolution, offers additional options. So again, other options, suggestions, we are certainly open to suggestions on how the department can get that out, or how schools can do that as well, to try and work together collaboratively to come to some sort of resolution short of getting the parties involved in hearings.
I just, since we're talking about information and communication, I know we all know this, but I think everyone sitting around the table here's first language is English. I don't know. I'm just saying it's probably the case. That's not the case with all families in Indiana. That's not the case of all students with disabilities in Indiana. And we need to, I just want to I want to thank the department for continuing to make resources available in more languages. I want to encourage you to continue doing so, so that we make sure we're taking care of all Hoosier families. And I also want to say that InSource reflects those priorities. Dana's speaking of when a family calls InSource, they're typically not having a good day, and the first thing we say is, have you talked to the director? Sometimes the director doesn't know, and that can help resolve the problem before any of this other stuff happens. So the resolving problems close to home directly is a great way to go. I think we also need to recognize around this table, it doesn't always work. The word is not always followed, unfortunately. The promise is not always kept, unfortunately. And when that happens, parents go looking for that next step in the process. Well, they'll be taken seriously because they're not taken seriously earlier on.
I would reiterate what Joel said, though, is that oftentimes the director is not aware that there is a problem. It happens oftentimes in complaints that we get when you know, anything we get, whether it's complaint, hearing, or mediation, goes to the superintendent because they're the CEO, if you will, of the school corporation. But we have always made sure that the director becomes aware, you know, the same day we get it, that there is an issue, because we all know that it's the director who's going to actually respond to these things. And oftentimes, that's the first time that the director ever heard that there was a problem. And that also, though, leads, I think, to a high rate of resolution of our complaints. That if you look at the statistics here, you'll find that most of our complaints anymore, you know, get resolved short of going all the way to a report. And in the last 4 years of those, you know, less than half of the complaints that we received resulted in a report being issued, and of those reports that were issued, only it ranged between 15 and 30% of those found that the school was in violation. So I think that everybody is doing a better job, or schools are doing a good job of trying to work out resolutions with parents and better complying with the requirements of Article 7.
Is that the distinction here, that between with reports and with complaints with findings? With findings is substantiated?
Right,
okay.
right.
Okay. Thanks.
So I'm a little geeking out here and finding this interesting as a practitioner and researcher both. This was actually an outcome, a finding of my research, that directors receive requests for due process hearing unexpectedly. That was a pretty significant finding in my research. Words like out of the blue and didn't know it was coming, never talked to this family. So I love all this idea and energy around how we can help parents know their options and communicate with the directors and the work of the DOE to encourage that. I also wanted to circle us back to a point that was made earlier. As our group continues forward and make our recommendations, just being very clear about all of the different alternative dispute resolution options, because it can get very muddied in the options. We haven't spoken much about facilitated IEPs yet, and I don't believe we've yet spoken at all about the resolution process, which comes after a request is filed and there's an opportunity to resolve the concerns before the hearing proceeds. And also from my research, the experience was that the resolution sessions are unproductive, that we're not being able to settle in that meeting the way it was intended when it was added into IDA. So I think there's also, I believe there could be a state that has mediated resolution sessions. So maybe Indiana wants to consider that. Right now it's generally, and we try to keep the legal parties out of the resolution session. And at some point, if you're interested more in what that looks like from a director perspective in a resolution session, I'd be happy to share as to why I'm saying that it's unproductive.
So are you guys referring to, when you say the director, are you talking about like the director of special services?
At the school, yeah. The special ed director of the school, yeah.
So they have the public agency reps that are there. So if the director is saying like it's out of the blue, we didn't know about it, because they don't go to the meetings, but there's assistant director of special services that go, and some school systems have more than one assistant director of special services. So why doesn't the director know? Like, are they not communicating? Are their employees not sharing that, hey, this is a problem, this is going on? Because when you get to that point, it's never out of the blue. Someone within that school system knows, their employees do know. So where is that accountability of their staff informing the director of what's going on?
Yeah, that's a great point. And there's lots of opportunities for all of us to learn and be better at what we do. And I recall one of my research participants saying that they created a system of getting the parent concerns escalated to their attention more quickly, because building principals or public agency reps will be at the conferences, and a lot of times the director isn't. So having that process where principals are knowledgeable about, or even can recognize those sort of red flags of, like, I think this parent has some concerns and we might need to work a little harder to resolve these than just this one meeting.
Yeah, I mean, before I went to my due process, I'll be honest, I mean, I was on my third due process in 2 years. And I never met the director of special services until the due process hearing. Now, any of the times, over those 2.5 years, I never met the director of special services. There were emails and things like that that was exchanged, but there was never a time where they participated in any of the case conferences, didn't participate in the resolution meeting that we had, didn't participate in any of those things.
I think Brandy makes some real good points here, because I think all too often we are kind of looking at this as somehow faulting a parent for not bringing their concerns to the attention of the director, when the parent has been involved in a variety of, case conferences. The school sends whoever they think needs to be at that case conference, and if there are concerns, I think that the school people need to communicate amongst themselves too. So I think that ought to be part of what we look at too, is the communication process, and the burden shouldn't be on the parent to make sure that they get their concerns addressed to the right person.
It brings me back to the testimony, too, that we had in February and March that kind of started this whole group. There was somebody that had said, looking at our systems in Indiana, like our shortages, and I think, Tom, you mentioned that earlier, shortages of speech pathologists, sometimes you can't find them, shortages of special education teachers, and so, many schools are still hiring special ed teachers, and school starts in a week. So to train them and to get them into a case conference process and have them ready to go to meet the 800 things you need to do in a legal document. Well, it's not, oh, you mean money to pay teachers or, so there's, I think to your point, Dana, the broader context of what's creating some of these systems that, where things that we hope and want are hindering our ability to get to that too.
I agree completely. I don't think you can find a school district in our state that isn't hiring someone to work in special education in some way, shape, or form. It's a system under stress. And I think a lot of what brought us here today, knocking back a few steps along the way, is the fact that there are some systemic challenges that are coming up, and wow, there's a lot more complaints now. Well, I hope this working group can dig into what some of those root causes are. I think Dr. Balsley is correct that there are systemic challenges. It's pretty obvious that they are, but that's a motivating factor for a lot of these difficulties.
And I don't bring them up to make excuses for them. I just bring them up as they are our realities. And so as we problem solve together, we have to be aware of those realities as well.
I agree.
Yes, I do think that this might be the root of what's all going on with this working group. Is communication is key, whether it be the parent talking to the schools or the schools talking amongst themselves. But I think that this kind of goes hand in hand with communicating the resources with the parents. They're inundated with so much information. They've been overwhelmed ever since probably like the diagnosis, because they've had to jump through more hoops of fire than a lot of other parents that don't have to go through all of this. So just continuing to communicate with them, and I know that there's a lot on teachers and special education departments. They are very, very worn thin. But just following up with an email or a call saying, hey, did you get this information? Whatever, not just giving them a handout and thinking that they read it, but actually following through with them to make sure hey, I know that I gave you a lot of information. Did you have any questions? Just that follow-up, I think, will definitely help, along with schools communicating amongst themselves, will be a huge aspect of this.
I think that's huge. And one thing we haven't brought up yet is relationships, and when we get into a hearing, the relationships are negatively impacted. That's all throughout the literature. That was a finding in my research. And unfortunately, when we're in the due process situation, we aren't communicating with the families. And sometimes these can go on for 6 months, 8 months, longer than that. And yet the child's still coming to school. We're serving a child, yet the parties that are responsible for serving the child aren't communicating. And that's really a bad spot to be in on behalf of that child. So what we can do proactively to work on that, to focus and narrow the complainable issues, those things, I think it would be very beneficial.
Ready?
Go.
Okay, number 6, patterns of complaints that emerge regarding special education rights and services, in order for the department to develop strategies to better resolve issues that lead to a particular pattern of complaints. wasn't entirely sure what this was, but what I did was kind of compile the issue, to the extent that I could, the issues that we have that arise in complaints, hearings, and mediations. Several years ago, I was asked by George Van Horn, who's the chair of the State Advisory Council, what was the most common issue that we had in complaints? And I said, well, I said, anecdotally, I can tell you that it's failure to implement the IEP. And he said, well, do you have any statistics to back that up? But because we didn't have a good method of compiling that. So now that we are trying to, and again, it's still somewhat in its infancy as far as identifying issues that we can do so through iChamp and pull that out. Complaints, that is by far the most common issue that we have. But for mediations and for hearings, it's more appropriateness of services, appropriateness of the educational placement or eligibility. One of the things that, you know, I did, I think at its June meeting, go and talk to the State Advisory Council, at least its last one, whenever it was, to see if they had suggestions and ideas for this group and looking at the 9 topics we had to look at. And one of the things that they suggested was that the department provide additional training to schools and to parents about the facilitated IEP process, and or additional training for other people to do that as a means of resolving things. Information that I got from at least a couple of other states indicating how they tried to address some of these things is that when you identify the more common issues that arise in complaints or in hearings or mediations, as for the state to provide training to parents in schools, you know, on particular topics. So I just throw that out there as something that you might want to consider, not necessarily volunteering our overworked staff and short-handedness to do that, but it's something to at least look at if additional training in certain areas for both parents and for schools could be beneficial.
I have a question. Out of curiosity, why are the issues available because I'm guessing this is from iChamp, right?
Yeah.
Why are the categories different for hearings and mediation?
Okay, what we did for, it kind of stemmed from what we used to do when we did things by hand, and as we kind of, you know, converted over to an electronic system. So the issues identified in complaints, in hearings and mediations are generally phrased and framed much broader than what we do in complaints. And so we had more of these broad categories, and we just asked our mediators and hearing officers to go in and check certain check boxes. When you look at complaints, and we only have those for 1 year, we identify complaints to a specific section of Article 7, because we're looking at procedural compliance. So the identification of those issues are somewhat different.
And that's done by the investigator?
Yeah.
Okay.
So I had a similar question. I was just wondering in the hearing issues, how those were coded then to get this quantified data.
Yeah, it's just kind of listed there the way it is.
I think, if I'm understanding right, so the mediation issues and the hearing issues, the actual list is kind of probably a drop down or a checkbox within iChamp, versus the complaints, which are the sections of the IAC that the investigators check. So I think those are the available to the individual mediator and or hearing officer to choose from.
Okay. And I was just wondering, like in 2018, parent participation, there's 24 issues. In 2019, 21 issues. I just picked one thing at random here. How did you get that count on each of those? Did somebody go through and code
We asked
them,
the
or-
hearing officers to, in each hearing that they have, to check off the issues.
Yeah.
Okay, and it is, what is the hearing request then? Is that where the issues come from? Like,
No, it's going to be how the hearing officer framed the issues.
okay, how the issues were framed, not necessarily in the way that they were requested from the
It
beginning.
might not be. It might or it might not be.
Okay.
It's the interpretation of the hearing officer, I think, is.
Okay, I bring that up because something that also is worthy of our attention is the use of boilerplate templates when requests are filed for due process hearing. We see across the state a very similar practice of this request in one district looks very same as a request in another district, and in fact, sometimes names aren't changed, and it's almost like, I'm gonna throw everything, including the kitchen sink, at the wall to see what sticks, and to give negotiation power, and by not defining and narrowing issues on behalf of the student, that takes away from the inefficiencies and expediencies on behalf of children that we're looking for. So I wondered if these counts were potentially elevated by the practice of boilerplate templates and filings.
It may or may not be. I can't tell you that, Angie, because I don't know whether, especially for the vast majority of the hearing requests that don't result in a hearing, I don't know whether the hearing officer checked off the issues before or after the hearing officer might have framed the issues. If the whole thing got resolved before it actually went to hearing, but the hearing officer still had to go identify issues, they might do that based upon what's in the hearing request.
I'd be curious, again, this is me.
Our hearing officers how they do that.
Sure, this is me being geeky, but from the complaint initially, the request, to what was settled on, because a lot of the things get like, oh, we don't actually go down that path. I'd be
Right.
curious the numbers and how they compare in that.
And I'll just make a comment on this, and as an attorney, this is illegal practice. I mean, this is not specific to special education law. If a filing's being made, you're gonna include those that may be at issue, that there is a, oh, you know, that one time they didn't ask the parent, it's gonna be included. You know, even if the main issue is placement, or the main issue is appropriateness of services, they're gonna go through the IDEA, and they're gonna list the ones that are applicable. I don't, you know, I can't speak to the templates, because we don't use templates, but an attorney's gonna go through the law, and they're gonna mark which ones that may be applicable. So what ultimately results in that, either from a decision at a hearing or from a settlement, is very likely, you know, not gonna include all of those. Just as a similarity in the legal practice, prosecutors filing multiple charges, you know, the initial one and the underlying ones, they're only looking for the one, but they're going to include everything. That's just across the board legal practice. So I don't know how, you know, that will change. I get, and I don't disagree with your point, certainly, that it muddies the water. And when this is the primary issue, it's going to be better to focus on that. But from a legal filing standpoint, I don't see that practice changing in this specific area of law when it's kind of across the board how it's done, if that makes sense.
I appreciate that. That's very enlightening. And that brings me back to this. These are administrative rules, right, for our own laws. This isn't court. This isn't like a grand jury. And so the fact that it gets so legalistic in some of those practices that are utilized, it just makes me wonder about like the expulsion process when they're like, yeah, I think there's an administrator in the school that handles that. Like, why does this become so legalistic and tied up in attorneys? Even at the point before it gets to the hearing, but at the request state too.
So I can speak to that a little bit as well. The educational due process is very legal. It is the closest thing you will get to a legal trial outside of court, I think, in my experience. Even compared to other administrative processes and hearings, like vocational rehabilitation is not as trial-like as an educational due process hearing is. I don't know why that is, but it is very legal. I mean, you know, our attorneys prepare for a due process hearing if there's going to be one, like they're preparing for a state court trial. It's that's how it's run by the ALJs. It's not that this is, you know, they would much prefer it to be more of probably an informal process, but that may be because in special education specifically, there are lesser administrative options. There's the complaint procedures, there's the mediation, there's the resolution meeting. So there are those lesser options available, that kind of those informal, more informal, but the due process hearing itself is very legal. And that's just, it's operated that way by, I think, both sides and both attorneys.
And IDEA doesn't, nor am I saying I'm advocating for a tiered system of dispute resolution. So while we have all those other processes, we're not required to exhaust those prior to that very legal. And then don't we just wonder why? Like, why? How intimidating for families, for the teachers who are just trying to do their best for kids. Like, when you get into that situation, it's so stressful and strainful on families and schools. Like, why do we make it so complicated? And I'm just going to leave that out there as a hanging question of, do we have any opportunity to make this better for people?
Right, and I don't have an answer for that. I will say that while we don't have a required tier system, we certainly have a tiered system in Indiana with the other lesser options. And, if we look at the specific numbers, which it's amazing how well Dana and her staff did to put these together, due process hearings are very few and far between in Indiana compared to other states and compared to, how many kids there are and how many districts there are. So it's not I have a special education issue, so now I've got to go through this very intimidating trial-like process. It's just only those ones that get to this step, and, the numbers aren't that great. But I don't disagree with you in that it is a very formalistic and a very, legal process. But there are those lesser tiered ones that, while are not required, are available to the folks to try to settle it.
And I do just want to clarify too, like when maybe only 4 or 5 go per year, we're still getting more requests. Like that's on the uptick a little bit. We hit over 100, I think, last year, and we hadn't been that high in a while. And that point of the receiving the request, we're still engaged with attorneys. We still have
Certainly.
the shadow of the law hanging over. We're still doing witness preparation with teachers who are getting paid $40,000 a year. You know what I mean?
Right.
Like there is a lot of the stress and strain, and that's really the focus of my research too, is that process from when you receive it to when it's settled before it even goes to hearing. I just think, with 95% of them happening in that regard, it's still that legalistic process.
Right, and I'm sorry, let me clarify my statements. I was referring to the few and far between as being minimal, as being those 100 filings, not before they go to hearing.
Yeah.
When we look at the number of kids receiving special education services, the number of school districts, I think that's a very minimal number, especially when you're considering vocational rehabilitation as a comparable on how many those are filed and whatnot. In my mind, my subjective opinion, that's what I was referring to as the number filed. Because I 100% agree that when that filing happens, the legal process certainly begins at that point. Because you're now prepping like it is filed in state court for an initial trial. So.
And you said that it is intimidating, and it is very intimidating, especially for parents.
Absolutely.
I mean, we considered in a IEP conference with 20 people from a school system. Those 20 people are placed there for a reason. All of those 20 people are not sitting there talking, and then you have a parent, right? When we get to the point where we are filing those due process, a lot of times there's egregious things happening that we have no choice but to exercise that right. I believe this legislative session, we heard from the parents up north whose child they built a chair and strapped the child to a chair. Imagine the trauma. So what should they have done? Like, should they have just kept going back to the school and having those conversations with the school as to why have you built this chair for my child? I think a big picture that we miss that's not talked about is, why are these being filed? What's going on? Why are these being filed? And I think that's how we can kind of curb some of those costs, is to look at those questions. Do we know, is there any data on the number that do go to due process hearings? Like, do we know who is the prevailing party? Do we know how many of those are on behalf of the school systems or on behalf of the parents?
I can't give you that, but we can find it for you.
Because I think that would also be, the private attorneys and parents, because it is so costly. Again, we don't have insurance that's covering our legal fees. We're paying for those legal fees ourselves. So the private attorneys that are taking these cases, they're not going to take a case to due process that's not going to win. They're going to take a case, if they have a good case, those are the ones that they're going to take to the due process hearing, right? So it would be interesting to see how many of those are being found in favor of the schools versus how many of those hearings are being found in favor of the parents.
All right. We'll get that information for you for the next meeting, okay? I did want to respond to Angie on when she talks about the numbers going up. Yeah, fiscal year 2018 was the highest number of hearing requests, actually complaints and mediations that we had all in the same year. We hit 106, but for fiscal year 2019, that dropped back to 84. So it's not It's not a continuing.
Yay, glad to hear that. That's a relief.
However, our complaint
Complaints went up.
investigators will tell you it is for them.
For the record.
2018, they hit a record high of 139 complaints, but for 2019, it was
147.
So, but our hearings and mediations dropped down. So
It attests to your good work, Patrick. People want to come and get your help to solve things, right?
Yeah, and that's on the record, yeah.
And Dana, I would like to thank you for offering the trainings. I know that your staff is stretched thin too, but I think trainings for schools and parents is key because the more educated they are, I think the less it will keep attorneys out of the room. No offense, Tom.
None taken.
But I'd rather get things done without the legal fees and the attorneys in the room. So I think trainings would definitely help with that.
So Angie, maybe we can work together with iCase if your roundtables would offer opportunities for us to offer training and invite parents and school people, provide us the venue to do so.
Oh, I'm certain that can be worked out.
Okay, number 7, appropriateness of non-disclosure agreements and settlements involving special education in public schools. The department really isn't a party to these agreements, but I would offer the fact that non-disclosure agreements in any sort of settlement agreements to settle litigation are extremely common and generally to be expected. I just offered the couple of comments here that when you're talking about agreements involving children with disabilities, even without it being a non-disclosure agreement per se, personally identifiable information, certainly about the student, could not be disclosed by the school anyway. However, without having it being a non-disclosure agreement, the parent would always be free to disclose anything. And part of what you're doing when you enter into a settlement agreement is you don't want to make that information available to, oh, now I'm going to encourage another parent to do this, for whatever. On the other hand, though, is any money that's spent and the cost of this litigation is the expenditure of public money. And I think generally that the public has the right to know how public money is being spent. So those are just my observations on non-disclosure agreements.
I agree. I mean, they're largely asked for when one side is offering settlement. I can only speak to IDR, but we will largely negotiate those out. It kind of, it's a deterrent to parents in our view. We've also seen the unfortunate practice of non-disclosure agreements being structured with liquidated damages agreements and clauses, so that if the parent says something to somebody about this very broad incident, that there's automatic $5,000 damages to the school, plus attorney's fees on recovering those. Those are kind of often written into the NDAs, which we didn't agree with. But yeah, I think from a public practice standpoint, with these being public schools involving kids with disabilities, I think it's a worthy thing to discuss the appropriateness of the NDAs in these specific agreements. As Dana noted, if the concern is the confidentiality of the kid and who's involved, even without the NDAs, that can't be revealed. So it's really just the allegation and what was settled for money-wise, attorney's fees, et cetera, that would be public. And I also can speak to most of our clients. They're not wanting to go scream from the mountaintops about this either. So, I imagine there are those few families who are, would like to educate the public on how they feel their children's rights have been violated. But in that situation, if they have been violated, then I could see that and see why they would want to be able to do that. So that's my comment on that, on number 7.
From just some past experience, some of that sometimes is not school's determination when that's turned over to an insurance company. The school then pretty much is just along for the ride. And the insurance provides, in some cases, their own attorney. Sometimes they do consult with school, sometimes not. So if settlements are reached or determinations are made, school may find out about the same time as a parent finds out about those types of things. And so things like non-disclosure and statements, schools have very little opportunity to disclose information based on all laws that apply to all students. But to keep in mind, sometimes that we talk about, well, why does the school do this or that? It's pretty much sometimes at the determination of the insurance process that they say, okay, we're going to settle. We're going to determine that this is the final, and here are the agreements that we've come to, and you're given to. Here they are: superintendent, school person, principal, parent. We didn't agree to them, but they're our insurance provider, and so in order that we have to comply with what they want us to do. So that in itself, sometimes where we have the non-disclosure issues, I've encountered one or two in my career where, the parent, the school, we had good communication, good opportunity, but when it got to the insurance involvement, it kind of discounted that past relationship and just said, here's our final determinations. And we were left with that.
Yeah, and
I've not encountered many non-disclosures because from a school standpoint, there's not a whole lot school system can share anyway.
Right.
And I don't know as far as parents, of course you don't talk about it after.
Yeah. I think I'll make 2 points. I don't know if you're being kind or not, but those are certainly the attorneys on the insurance side, not the insurance company who's doing so.
Yeah.
So it's certainly the attorneys who are wanting a non-disclosure for their client being the school.
Exactly.
Yes, I mean,
Well, it's
those.
an insurance attorney.
Exactly.
Client's
So it's not the school.
insurance
Exactly.
company.
Yes.
It's
Still
not
the attorney's fault. Yes.
Right. So-
Yes, and I agree. But again, in our practice, we don't typically agree to them, so they can be negotiated out. And certainly if the law says they can't be in special education settlements, then the insurance company wouldn't be pushing for them either. But I think you make that point, which is an important one, that schools largely can't disclose this information anyway for FERPA. So this really only handcuffs the parents. And in those cases, obviously there's going to be some bad eggs, but largely it's parents who feel that, their kids' rights and their receipt of free appropriate public education has been, infringed upon. And now you're saying, we're going to settle with you, we're going to give appropriate services, we're going to do whatever, but don't mention it to anybody, and that's the public policy of that, I think, is kind of an interesting discussion that we should have, and whether that's appropriate or not. Yeah.
I agree. There's a lot that the public does not know about what transpires. And I'm sure IDR deals with this a bit more than InSource, but I hear stories that make me sad. And I'm sure special educators do as well. And I think I just wonder what the public would do with that knowledge. And if that might motivate some helpful change around some things as parents and families, community members become aware of what just happened over there at their school where their kid attends. So I'm not a lawyer, but a lot of things happen that I think folks ought to know about. So
I think it was very telling as well. I don't know who attended. I think it was 5, 6, I don't know what it was. It was one of the hearings on this issue. I know Angie was there. I don't know if it was Brandy or not. It was maybe one of the other parents, and some of the legislators asked about a specific special education situation that she was there to talk about, and what deeply impacted her child, and she couldn't talk about it or didn't know what she could talk about because of the non-disclosure agreement that was in the settlement that she agreed upon. So I think that was just kind of telling about how prevalent these are. And the effects of them. I mean, she wanted to show up at a legislative hearing to talk about how this impacted her child and the services that her child needed because of disability, and she wasn't free to talk about it or didn't know if she was free to talk about it. And I think so that's just kind of eye-opening. And I think it was eye-opening to the legislators because I think this language was added after that testimony. So I thought that was interesting.
And I think it's important to be able to share those things, especially with other parents who may be going through similar things. I mean, it's not necessarily to take the school system through the mud.
Mm-hmm.
I mean, I have been very vocal. My son has been very vocal and has advocated since, because my hearing was just in the last year. My hearing was last November, and it was 5 days, 8 hours a day for 5 days. And so when the decision came out in December, that is one of the, somebody had caught wind and the news, you know, had spoke to myself. I didn't put my child on the news, but we have been very vocal, but again, it wasn't dragging the school through the mud. It was more so letting parents know there are options. You do have rights, because those things aren't willingly giving out by school systems. So, you know, and since then, we have went public with, but again, not dragging the school through the mud. I could talk about that because it's public record. The other two incidences I couldn't discuss because of the non-disclosure agreement, but I got flooded with messages from parents once I was able to discuss it. And it was nice being able to give them resources. But again, the stories that you hear, it's absolutely heartbreaking, because we have to send our children to school. You're sending your child to a school and you're trusting that they're doing what they should be doing for your child. And they shouldn't, they shouldn't face the trauma that some of them face in the public schools. Shouldn't happen.
Number 8, whether the department shall establish a special education board of appeals to review administrative hearings or findings. I think I might have kind of touched on this before to say, we used to have a board of special education appeals. We refer to as the BSEA. A 3-member panel. They served for 35 years or so. That regulation, it was all done by regulation of the State Board of Education. That was repealed in 2009. So the last actual appeal I think that the board heard was probably in 2010, because they would still apply to any hearings that were pending at the time that regulation was repealed. It was the best avenue, I think, that we had to serve as some sort of review of our hearing officers' decisions. I just throw it out there that we had one for 35 years. I thought it worked well, but we no longer have it.
Dana, you know, this was an area that resonated with me, right? It was like, why was it gone? And so we've kind of heard some of that, and we've heard things like it was budgetary or what have you. But you just said from your perspective, it was one of the best ways. From what you've seen in other states, other places, is that still, do you consider that still to be a best practice? Am I making sense with that question?
I would sit there and say that's probably not true in other states. I believe there's no more than 10 or 12 states that are what we refer to as two-tier states that have.
I believe there's 5 or 6. 5 or 6
It's down to
total.
5
Yeah,
or
I
6
can
now?
get the names of those states if I have
Okay,
them.
I know Ohio is one. They have a state review officer, just one individual that serves. So, yeah, well, the last time I'd ever looked into it, it was in the neighborhood of 10 to 12. So, and in talking to Cadre about it, they've indicated they've never heard of a state going backwards to go from being a 1-tier state to going to a 2. So most states that had been 2-tier have now reduced and gone to 1-tier. So that if you want to appeal a hearing officer's decision now, you just go directly to court. Whereas what we had up through 2009 is you appealed first to the BSEA, and then you could appeal the BSEA's decision to court. So that's not what most states do, to have a 2-tier.
Okay.
And why did that get repealed?
I'm sorry?
Why did that get repealed?
I've been told it was budgetary reasons.
Okay.
Back in 2009.
Well, I guess I would just add, I think when you think about a 2-tiered system, you also have to think about costs to the parent, to the school corporation, and then I think you have to remember the duty to train those individuals. So it is, the Department of Ed currently trains the hearing officers, so the department would have to assume that responsibility of training the members of the appeals board.
Do we know like how many are taken to appeals now that they actually have to go to court versus how many went to appeals with the whole board?
Kim, do you have any of those statistics? Is she back there? Okay, we can get that for you, but again, right now, we're in the situation where we only have maybe, an average of 4 hearings a year, Whether that would change if there was a BSEA, I don't know, because I think our numbers that actually went to hearing dropped after the elimination of the BSEA. So I can't tell you reasons. I could speculate, I can, make up things, but I can't give you any hard and fast statistics on any of that.
I'll just add anecdotally, because I was at the department when the BSA existed, and, quite honestly, they just affirmed the vast majority of the hearing officer decisions. So my recollection is there were very few that resulted in a reversal of the hearing officer decision, because their standard of review is very narrow. I mean, it's limited, as Dana has reported here, arbitrary and capricious. That's a pretty high burden.
There's a lot of deference given to the ALJ as well.
Right.
Yeah.
So
I know that this is some years back, but is there any way we can get any kind of data from those last few years on how many the board heard and whether those decisions were reversed or upheld?
We can certainly look into
Okay,
that.
because that would just be interesting, I think, looking at it, if we're looking at it from an option, just to see kind of what the board did numbers-wise and what they did with the actual decisions.
I agree
Thank
with you. And then Lisa, from your perspective, from what you just said, I want to make sure I'm understanding. You would not be, so I'm asking you, right? This is kind of just a yes or no. You in your opinion, given what we have right now without that data, would not think that would be a good option to go back to having that.
that would be my personal opinion, yes.
Okay, that was what I was at, but I love the idea of the data, because my mind went to as I'm reading that, my mind went to, well, gosh, that seemed like a pretty good way of doing it, right? So I appreciate your opinion on that. Thank you.
If I could add some discussion on behalf of iCase around that, our consideration has been around the why. Like, it's a solution, but why? What are we going to get out of it? What's going to be the outcome of that? And I think a lot of the interest was in accountability for hearing officers without, like we talked about earlier, without oversight, without evaluation. So if there's another way we can get to oversight, potentially, I think that could reduce maybe the why we were looking at this.
And especially, as Dana said, it looks like the numbers have gone down of actually going all the way through due process without the Board of Appeals. If we could look at that, like the reasoning.
I'm going to echo. I think, especially part of, I think, I'm not going to say the chief reason, but one of the chief reasons that this was created and the legislation was being discussed is costs. This is not going to eliminate or lower cost if there's a board that's being created to oversee, and it's only going to lengthen some of the very already lengthy aspects of due process. And there is that court step of judicial review if they wanted to take the next step. So.
Number 9, whether a dispute resolution ombudsman within the department would reduce costs relating to legal advocacy and facilitate more efficient resolution of disputes. I think what I wrote here is kind of sitting there saying, parents and schools, for that matter, can call us and we provide information, but we are not in a position, our staff, to be able to try and really resolve disputes, because we still need to be able to be seen as an impartial complaint investigator or whatever, so we don't want to take particular positions. I mean, certainly if a parent calls us, we will go through some of the same things we've already discussed, like encourage the parent to discuss their concerns with the school teacher, with the teacher of record, with the director, and reconvening the case conference, or considering a facilitated IEP meeting, or doing all these things. But we are not going to turn around, and I'm not going to turn around and call Angie and say, hey, Angie, I got a call from a parent here. Why don't you try and resolve this? Whereas if you had somebody else who wasn't on our dispute resolution team, they might be able to do something like that. I mean, it's an option to consider and look at, but we can't overstep, because if the parent turns around and files a complaint, we don't want the parent to say, well, you already sided with the school on this, or for the school to sit there and say, well, you already took the parent's position. Because we still have to maintain some impartiality here on our processes.
I would like to see if like other states are using an ombudsman, just because as Tom stated, that would add to the cost, but is it also deterring people from going all the way through due process and saving the cost there? Like, is it balancing out? And would parents feel comfortable with going to the ombudsman? Because it's like, okay, you are the DOE, so are you going to be signing more at the schools? It's, you know, having that little bit of a bias.
And what the perception might be.
Yeah.
You know, one of the things that Indiana, and I have no idea, maybe Joel knows whether other states do such things, but we do have one of Joel's staff kind of embedded in our staff, Lisa Paddock, who is an in-source employee, physically sits in our offices. So we have this, you know, advantage, if you will. If a parent calls in and they're having issues or whatever and they need help, I can sit there and say, you know, would you like to talk to InSource, someone from InSource? And then Lisa's right there and can do that. I mean, I can't just transfer the call to Lisa because the parent called DOE, and I can't share that information with InSource, but it helps right there. And then, you know, Lisa can talk to them first, and maybe then if they're not in Lisa's area, physical, geographical area, however you divide up the state, she can get them in touch with the right InSource representative to do that. So that kind of gives us the best of both worlds there, if you will, without having that ombudsman position.
Are all of the folks on your team attorneys?
Our complaint investigators are.
Mm-hmm. Have they always been?
No.
How come the shift?
My suggestion. I think that it works better to have complaint investigators who understand what findings of fact are and conclusions of law, and it helps with the process. So that process, the requirement actually probably just started 2015, huh? 2013? That long ago, huh? When you got hired, okay.
I'll just note on the ombudsman, I think there's two considerations here. If you're wanting the ombudsman to kind of look into an issue and kind of make a decision, I think that the complaint procedure's there already, that it's already there and it's kind of duplicative. I think in the legislative session when this was first brought up, if I recall, what came out of these initial thoughts were, what we're really looking for is somebody to help and advocate and advise, which are those no-cost options like InSource and IDR, which I think morphed into, okay, now how do we educate parents about these options that are already out there? So I think, you know, if for the discussion of ombudsman, I think we need to really kind of narrow down the reasoning and the need for that entity or individual or whatever, whether it is a look at the issues and kind of adjudicate, make an informal decision, because again, I think that already exists with the complaint procedure. And if it's the advocate kind of educating them on their rights and IDEA, et cetera, it's okay, just as we discussed an hour ago, how are we best going to communicate these options that already exist to the parents, where they can go get no-cost assistance and educate them on those rights, or represent them from an advocacy standpoint. So.
We do have parents that call the special ed the general line, and we're kind of on a rotation as like a certain day. Like I had this past Tuesday, and so parents are calling, asking about a whole host of things, but a lot of it will be Article 7 complainable issues. And I think myself and the investigators, we walk that pretty fine line of just saying this is what Article 7 says. But I know, and they can all tell stories as well as, you know, a parent will take me and just, you know, reading Article 7 and run with it and either tell an Angie, or if it, like, you know, it was a classic example of I told a parent and I told her something about Article 7, she filed a complaint, I believe it was Tracy's, and she said, well, Patrick said that the school already violated, you know. It's a fine line to whether it's someone just taking a gen line call as a complaint investigator or an ombudsman. It's a fine line to not give something that the parents are going to run and kind of use or misinterpret. I don't want to, or not. Yeah, it's hard.
So federal special education law invented this cool thing called the Parent Center. And it exists for reasons like this, which is there's a lot going on, and it's helpful to have a parent explain it to another parent, and that's what a Parent Center is. We are very proud of and presented on at OSEP National Conference earlier this week on some of our collaborations, including our collaboration with our state. It is a wonderful and envied practice in our nation, actually. So I would point to that as an asset for families in Indiana and for the state, because at the end of the day, we're all in this together, right? And it's when these individual disputes arise that parties kind of form and polarize. But I think systemically and holistically, at the end of the day, we all want to see the same things happen.
And I just wonder how a parent, when they have a concern, can get that, like, here's another friendly parent. I'm trying to have eye contact with you and talk into the microphone. It's not working real well, but
I'll lean this way for you.
how a parent can have the empathy, the understanding, let me just talk to another parent about this. You know, when they call the DOE, they get an attorney right away. And no, you guys do a great job encouraging that. But like you said, you walk a fine line, and you really can only read them what's in the law. It's like you reading a brochure to them, right? Like, you can't get into the, have you really stopped to think for a minute about the relationships here? Have you, you say, have you worked with your director? But I feel like InSource has more of an ability to be that relatable, go sift through the emotion, the high emotion that's involved with this, and then to be able to help collaborate, just like where you said, Dana, you can't say, hey, why don't you try this first? Like, you can't really advocate any one position. You can just educate on the position. So in looking at either an ombudsman or how do we utilize InSource in an additional way, or the IDR, that's where I wonder if we've got an opportunity to be a front line for parents as they're working through it initially, and somebody that's encouraging, let's try to resolve this for you.
Yeah, I agree. And I certainly can't speak for the investigators, but I imagine they don't want those calls to answer those tough questions. I think they probably prefer InSource to take that role. So it goes back to the communication aspect. And I guess my question is, can you or do you recommend InSource as an option for parents when they call? Is that possible?
Yeah, no, I have a list right there by my phone of, some of it's just filtering into the right places. Sometimes they're have issues of discrimination, so I'm like, oh, you need to go to the Office of Civil Rights. Mm-hmm. But I have InSource on there. I have IDR on there.
Okay.
Yeah. I'm trying to think of I wish I had the list with me right now. But no, I do definitely have that right in front of me when I'm talking, just to make sure I have those to offer to the parent as well.
Yeah, okay, great, because we keep talking about how we get that information out, so I wanted to make sure that was hopefully something that DOE felt that they could provide information as referrals to InSource, because I think InSource is, like you mentioned, is the federally created center for this specific issue in Indiana.
It is. I think it's also important when folks talk to InSource, they realize they're not talking to the department as well. Mm-hmm. That helps it all work out too. So I think a healthy situation exists where if you call the department, you get the department, but the department might suggest, as Patrick says he does, and the rest of the team does there too, would you like to talk to someone else about this? And then we can get into it within the bounds of what's appropriate for us to get into, but with a clear line of, yeah, we'll take that step, or no thanks, and give the parent that option, because they don't have to, but it does help. It helps understand the contextual concerns that Angie brings up of what would it mean to file a complaint. I think that's like, if you didn't know we were talking about special education complaints and that was a specific thing, you might think like, I wanted more gravy on my mashed potatoes, or I didn't order an onion on my cheeseburger. Like, parents don't get that. Like, it took me a long time to figure that out. It's not just a complaint. It's like a complaint plus. I mean, there's just a new vocabulary you have to develop to realize, it's not just sending it back for more sauce. There's more going into it than that. So anyway, I do think there's some contextual information that do help families realize what is really going on when they file a complaint that isn't immediately available within the terminology that the field uses. So.
sometimes parents don't even know who the characters are in the play. I mean, oftentimes we get calls and people are thinking that we're IPS or that we're USDOE, and you know they're not even sure who's their go-to, let alone you know what are the right questions to ask.
Yeah.
The bevy of options and whatnot. So
Yeah, that's the conversation we have, is we take the matter of conscience that's compelling them to pick up the phone, and we help turn that into, okay, here's what you can do. And oftentimes it's convene a case conference meeting as just one of the early steps. But that's what we do, is turn that like, okay, so you're not happy. What do we do about that?
There are states that have this approach, so as we study, this, we could look at what does that look like for them and what could that look like in Indiana.
Dana, was that it for
That
you?
was it.
Okay. So, so Tim had made I'm gonna put you on the spot here for a minute, because you'd made a suggestion that I thought was pretty good, about this, is to maybe take and have between this meeting and the next meeting, and help me characterize this if I'm wrong, Tim, in what we said, but a chart, if you will, with the 9 pieces. We've had a really good discussion. I know I've got more things now running through my mind from the things that you've said and the things that I've learned, is to then get something back to compile. We need to make sure that Dana's got, you've had a lot of things asked of you and your team here, but that we could get other questions answered or other things as we get this digested, right? Because I think now we've got to digest a little bit, or at least I do. I'm thinking you all probably feel the same way. So put that together. Did I characterize that correctly, Tim? Come up and rather than me paraphrase you, how about you just quote yourself?
No, that was a good summary. What I'll do is I'll put together a chart, as Dr. Ernest mentioned, that outlines the 9 points in the legislation and seek feedback from the members of the panel as far as suggestions, or I should guess areas of concern with this particular point, as well as potential solutions and resources that could be something that the group could discuss. And I'll compile those responses, and that's something then the committee can discuss together. And just kind of going through, these are recommendations that, some people put out there. Are those viable in Indiana? If we want to pursue those, what's the next step? Is it a legislative matter? Is it a regulatory matter? Or is it just pure policy and putting something on a website? So that would be my suggestion for next steps.
Would it be all 9 at once, or could we chunk it and maybe take 3? Because there's a lot of, if you spend any time on the Cadre website or looking into other state approaches, to think about all 9 at one time would be kind of overwhelming.
Oh, I don't know if we could cover, actually discuss all 9 in a meeting, but at least I could put all 9 in that chart, and we could continue to build on it as we go. But yeah, I agree that trying to address all 9 issues in one meeting, that would be.
But even from a focus
That was
standpoint,
not my suggestion, or not my thought there.
I didn't hear that, but.
Yeah, okay.
even if you're asking iCase to come back and say, hey, take the chart and then put your ideas and your concerns in here, I'd like to not focus on all 9 at one time.
Sure.
I'd like to be able to think about and digest maybe 3 at a time or something.
Yeah, so I think we've currently, tentatively, there's 5 more meetings that we're proposing. So when I put that chart together, I could break it out by, this many topics by this meeting date and that meeting date. And I mean, none of that would be set in stone. Obviously, there could be back and forth. And if there are ideas about what's a better order to go in, or a certain number of topics to try to address at a time, I mean, it's intended to be collaborative.
Cadre is a living, breathing thing, and that I recognize it and esteem it highly for the work they do in our country. And Angie's referenced them several times. I think they would be a vital resource to the working group, potentially Dr. Ernest.
Okay, thank you. I like that. All right. Next thing here, just to, and Tim referenced this, we had sent out a list of dates And, you know, at some point you have to start somewhere, right? Because we have to get these rooms arranged and those kinds of things. Does anybody have any real issues with, and I know we're not going to hit everybody, obviously Kim sent the you know, tell her we'll just keep you. No. I'll tell Kim that. Does anybody have any big issues with what we sent out with those dates? We wanted to get those out mainly because if you have them early, you're able to make that work, right? So am I seeing a consensus of we're good with what we've got there?
Could it be like in the afternoons on those days?
It'll always be, so here in full transparency, so legislature kind of as my role of being the House's appointee. So I'm chairing this and I'm co-chairing the accountability, right? So from the standpoint of like really having a real job too, so what I tried to do was make the accountability in the morning and make this one in the afternoon on the same day. Just so in full transparency, that was kind of selfish. I'm not gonna lie, right? But I think it, and I'm happy about it because I'm passionate about both of them and want to do that. So don't take that as, I mean, I'm excited about this, but I thought that was the most efficient way to maybe make that happen. And on most of them, we're going to be able to utilize the same room because these great people here, see, I'm getting a thumbs up over here. I think of you all, right? Because we're going to have to set up the room and that kind of thing too. So hopefully, if that makes sense.
Dr. Ernst, if it's possible then where we have agreement on those dates, would it be possible to get those out as calendar invites electronically?
Absolutely.
No problem.
That kind of saves these thumbs weren't made for typing, but it would be
Mine
possible.
neither. Yeah.
So the dates worked well, and I thought it was a good thought, and I don't call that selfish, I call that efficiency on your part to try to get the AM and PM coordinated. So, but if that's a problem for you, let me know.
Nope, I will get those calendar invites sent out.
Thank you very much.
Perfect.
Confirm that those are good dates.
And then I would say also then the last item on there, and there's other items, and we'll get to those too, but if you have things that you want to put on the agenda or those kinds of things, let us know that as well. And Tim and I can work through that, make sure that those are on there. And even the suggestion to the point of when it becomes appropriate, you know, I'm trying to think through when it is appropriate, because I love to have experts come in, and that's kind of been my MO on some of the things that we've done, whether it be grad pathways or whatever, that we would have that. So would really appreciate the suggestion of when you think those are appropriate, who is it, and let's do it at that meeting, if that makes sense as well. Anything else? Any other matters that you have? Okay.
Just a comment, if I
Yes,
may.
please.
My experience has been when there's a committee or a work group that comes together that has diverse background but yet common passion, there's a lot of great things that happen. And just in our short time here, no, it's not short for you, you've been here all day, but for those of us here, it's quite obvious that those two criteria are met with the members of this work. So I'm, again, very honored to be here and look forward to what I think will be a very productive outcome from this process. So thank you.
Awesome. Anybody else, anything?
Thanks for letting me proxy. Proxy.
You're welcome. You are welcome.
So, just to recap, so I think it's scheduled every 2 weeks, is that right? Every second Thursday?
That's
about, okay.
Yes.
Dates are in your book.
Yep.
Early
So,
August,
thanks. So,
August 8th.
if there's expectations or desire for us to have comments on some of these items, having those spelled out in advance certainly would, so we can schedule that work, would be helpful as well.
Okay. Perfect.
I have a question. I mean, I feel like studying what other states are doing would be helpful. So is there a planned activity or task related to that? Is anybody going to bring that information to the table? Or is that something that maybe if we decide we're only going to address 3 issues, then at that point we might look at what are
Those
other
3 related
states
to other
doing?
states. Yeah, go ahead. I'm trying to think through what the best process for that.
So obviously, we're still early in developing how we're going to proceed, but I will say that I have made some initial contacts to entities and resources that might, I think, address what you're just discussing as far as presenting information on how other states perform this. And if that's something the group is interested in, then I will definitely follow up with those conversations. And if you have any contacts that you think would be good for that, please send those to me. I mean, I can always use the help, and I'd appreciate it.
For clarification, how states do things, are you talking about how other DOEs, other parent advocacy groups, all the above?
Well, I can't speak to what Ms. Tensel was referring to, but I was referring to entities that are familiar with education dispute resolution processes in their states.
Yeah.
I think it would be helpful to evaluate with the known caveat that certainly we're here because not everybody agrees that what's working in our state's working. And we're not sure that just because they're doing it in another state that people think it's working there. So just with the known caveat of that.
I agree. I would like to see what other states are doing.
Mm-hmm.
And I'm sorry, I have one more question. So for instance, as a member of the committee, it's been a long time since I've really known what InSource does. So am I free to contact Joel and ask, really some very specific questions about their organization?
So, yeah, I'm going to bring, because I want to be legal on this, but we are bound by our
Correct.
open meeting law. That would be perfectly acceptable. I'm not an attorney, but I'm playing one right now. That would be, right? Now, if you get 5 or 6 of us, if you
Correct.
We just cut you out.
yeah, but then you begin to get that.
And I certainly understand, if I would email Joel and he would provide responses to my questions, then we might be triggering a public records request, and so.
Sure. Sure.
But I guess I was just thinking, if I had a better working knowledge of InSource, that might help me make some suggestions for, the parent communication piece.
So one very simple rule to follow or remember is one person contacting one other person is never going to be an open door violation.
Right.
Do you know what the first 3 topics might be, just so as our minds are starting to think as we drive home and over the weekend? And
You want to just go in order? Is that acceptable?
and is 3? I
I'm a
just threw out
simple
3
guy,
randomly.
right? I
Is that
can-
like what
I
you guys
can-
want to do? Please.
That seems easy to me. 1, 2, 3. Is that cool?
Yeah, I was just going to check what they are. Some of them are heavier than others, if that makes sense.
Some can also intertwine.
Yeah.
So it may be better to figure out what is better grouped together.
That's a good point. And there were themes today that I was kind of noticing, right? And I haven't had a chance to digest that part either. But there's some themes that came out that would be consistent within them as well.
I mean, the idea of grouping related items together makes sense, but I would really defer to the experts as far as which ones should be considered together. So if you have any thoughts or ideas on that, I'd say go ahead and send it to me. I could share that with the group, and if there's consensus on that, then we'll proceed in that fashion. That makes sense?
I think the grouping's not as, what's grouped together is not as important, that maybe we kind of bring those 9 down to a little more focused, and we still can, say we do 1, 2, 3. And then somebody says, well, on item 5, I had this thought. That should still be allowed in the discussion or at the determination of the chair. But I think as far as I didn't see, and I haven't again gone back and reviewed them at great length now that we've had clarification, where maybe 1 and 6 and 3 should be together and 2 and 5 and 7 should be together. I didn't see that. And if there are other thoughts on that, I would certainly hope that they would bring that to the table. But just to say every meeting's going to address 9, that could be a little, we could spend a lot of time wasting valuable opportunity, is my opinion. That's an opinion, Mr. Chairman. No clarification for you, Tim, just.
Well, we can, so let's leave it this way. We'll take a stab at this, and Tim and I communicate often, every day, at a lot of times. But let us take a stab at this, and then if you see things when you come out, because everything, I believe in iteration, right? So everything that we do will be iterative, so if you see something, we can always make changes. Is that good?
I have one other request too, just to keep on the table, since the bill recommended that we consider the opinion of DOE, OSEP on anything, if they have anything of pertinence. I know they don't do things overnight, so I don't know what we'd ask right now, but I think we need to keep that in the forefront, that if something comes up where this may be something that OSEP could contribute to, that we kind of consider that as we go and maybe get that, maybe a working group request into OSEP for an opinion, or however we want to do that, just so they have time to respond before we need to get a report to whoever we need to get to.
I would just opine that you're looking at, generally, could be wrong, 6 months to a year to get a response from OSEP.
We could at least make the request.
They have to run their
Yeah.
things through up the flagpole and down again, and,
The gauntlet.
yeah.
Anything else? Okay, again, appreciate your time. We will stand adjourned.
Thank you. Thank you.
Thank you.
Thank you.